Yes.
May I have your
Actors
lordship?
except chamber application.
Leave to mention matter from the list and determination of Justice Mojumdar. The interim order was still yesterday. The Justice
The
Mojumdar
matter has to be listed.
may be treated in the supplementary list, because it was there till yesterday. Now, the bench did not sit yesterday. My learned friend is here.
So let it appear at 2 p.m.
At 2 p.m. May I come back at 2 p.m.?
The list, supplementary list at
Yes,
2 p.m.
at 2 p.m.
Sub notice upon
Yes,
the
yes, I have, I have already given. My learned friend is here. I'll again give notice.
Yes. Okay, 2 p.m.
2 p.m. Grateful.
My lord, may I be permitted to mention one matter under the heading execution cases, my lord? Pursuant to the order dated 27 March, the matter was directed to appear in list on 1st of May. My lord, the judgment letter has already paid the decretal amount. Only 1.5 lakhs is remaining to be paid. He is willing to pay that amount. My lord, if the matter is just given a hearing, my lord, it can be disposed of.
So let it appear in the list. Give the slip.
Grateful, my lord.
May I take your lordships kindly to mention, my lord, two appellate side matter, my lord.
So mention on Friday.
Division, my lord, but my lord, my lord, this thing, my lord, your lordship has heard it, my lord,
Yes.
but it is not treated as part heard, my lord. Your lordship
Anyway, mention on Friday.
taking the hearing
No,
matter.
no,
my lord.
mention on Friday. Friday,
Friday.
I'll be taking appellate set matters.
May my lordship is to file the inventory and accounts in the department, my lord.
Yes.
Inventory and accounts. I am praying leave to file inventory and accounts in the department.
Yes. Leave granted.
My lord, may I permit to mention an execution matter, my lord? My lord, in this, the terms of settlement has been executed between the parties, my lord. I am praying that the matter might be taken up tomorrow, any day after that, the terms
So
can
let
be
it
filed.
appear.
My lord, grateful.
As I already had, but this is the appellate side matter, the part head matter.
Okay, mention on Friday.
May I have your lordship's leave to mention item 127 from yesterday's list? Your lordship was pleased to keep it on 12th of June.
Yes.
My lord, now, my lord, it's a very old suit where, my lord, I am the plaintiff and the bank is the defendant. On several occasions, when the matter is called on, it so happens, my lord, because of the preoccupations or engagements of the bank's witness, my lord, he is unable to appear. I was only praying, and I'm mentioning upon notice, my lord, I've served notice. If the matter could be fixed at any day, my lord, as per the court's
12th
convenience.
June, you have some difficulties.
No, my lord, 12th June it is not fixed because then they will come again and say that the bank's witness is not available. And this they have been maintaining and doing, my lord, constantly for the last 2 years. It has commenced, my lord. They are doing their examination in chief. My lord, I will cross-examine 1 or 2 days and finish it.
Yes.
Kindly, my lord, fix it any day as convenient to your lordship.
I have kept it on 12th June. Definitely, it will remain there on 12th June. It will be taken up.
Yes.
It is fixed for witness action.
It is not. It is there under witness action, my lord, but it is not fixed at any point of time. If it can be fixed at, my lord, 10:32.
Let it appear as to be mentioned.
Yes, my lord. May it appear tomorrow, my lord.
Anyway, any day it will appear as to be mentioned.
Before the holidays, if it.
No, definitely. Give the slip.
I will.
My lord, may I be permitted to mention for appointment of a special officer or receiver?
Which matter?
Any matter.
No. Appointment of?
Special officer or receiver or
Give your card to the court officers. It will be considered.
court
Give your
officer.
visiting card to the court officers. Yes, call the list.
Urgent set matter to be mentioned, item number 1.
My lord, I appear under the petition, my lord.
Yes, it was taken up yesterday.
My lord, it was called on, but it was adjourned, my lord. I was not there, my lord. There is some typographical error, my lord. Your lordship kindly, excuse me, I have marked it. Your lordship kindly excuse me, I have underlined and marked the portion which should be corrected.
Mauja Kantlia, this is
Yes.
missing.
Yes. Khatian, instead of Khatian, it will be Kantlia, Kntlia. And Kestorampur, TA, instead of TA, it would be TO.
So consideration amount was 77 lakh 25.
Yes, my lord, that is a mistake on my part. That is not, my lord, typographical error. My lord, there is no prayer that
So
it will be only per katha. My lord, your lordship kindly grant
No, in your petition it is 75,000,
75,000 per katha. That words were not there.
but total amount you have failed to mention in anywhere in the application.
No, no. That's why, my lord, I am drawing your lordship attention.
75,000 it is per kata, not total consideration.
Not total
So you
consideration.
better file an application. Let it be clarified. So far this amount is concerned.
Yes. I shall.
Later thing will be
Yes,
clarified.
sir. Yes.
It's better you file an application.
Yes, I shall come with an application. my lord.
Yes.
Yes.
Only I am making it not this week.
Yes. Without my lord application, it should
Yes,
not be
because this
incorporated.
amount
Yes.
is concerned.
Yes, my lord. Nowhere in the petition I have stated that.
Orders, item number 2.
This is my application, my lord. The petitioner being the trust, my lord, prefer this application before your lordship for confirmation of sale, my lord.
Yes.
My lord.
Yes, upon hearing the learned advocate and considering the facts of the case, this court is of the view that as the petitioners have been able to make out necessity for causing sale of the property and as no persons turned up pursuant to advertisement for sale published in 2 newspapers, the prayer of the petitioners to sell the property to intending purchaser, Srimati Kiran Singh, with whom agreement for sale is made, and as advance sum of rupees 5 lakh already received,
My lord.
the prayer is allowed.
My lord.
Let there be an order in terms of prayer A and AA of the notice of motion dated 2nd August 2024. Upon completion of the sale, the petitioners shall submit report before this court by 2nd July 2025.
My lord.
It is hereby made clear that with regard to stamp duty and market value of the property, the petitioner and the purchaser will be at liberty to place the decision of the Honorable Supreme Court in the case of Register of Assurance versus ASI Vapor Private Limited in Civil Appeal 8281 of 2022 for assessment of market value of property. In the event petitioner and the purchaser are agreed by the assessment of stamp duty by the registrar, they may prefer appeal before competent authority as per Stamp
Fine.
Act.
My lord.
Yes, call the next.
New motion, item number 3.
I appear on behalf of the defendant. My application GA11 is under Order 7, Rule 11 for praying for rejection of plaint. And on the last
Yes,
occasion,
Mr. Dotto, you are opposing this application.
I am for the plaintiff. On the last occasion, they had submitted orally that they will not file any affidavit to this application.
Yes. চেম্বারে গিয়ে এটা টাইপ ফাইপ করে তারপর রেকর্ড সমেত আসবে আর কি। তাহলে পিএটি দিয়ে মানে আমার পিএর কাছে পাঠিয়ে দিন, তাহলে এটা ইয়ে টাইপ করার জন্য, ঠিক আছে? ছেড়ে দিন, ওই আর্দালি নিয়ে যাবে। Yes, you are for the defendant number 1.
Yes.
না ফাইল করা।
The GA11 is my application under Order 7, Rule 11. Then the only point involved is limitation. Lordship, this is the suit property
Yes, which paragraph of the plaint you are relying upon?
Yes.
Page?
Lord will kindly take their plaint at page 9, starting from page 9.
Yes.
Lord, I will first take your lordship to the prayers and then come to the paragraphs one by one. Lord will kindly take page 24, the prayers in their plaint.
Yes.
Prayer A is for decree of declaration in respect of the ownership of the premises. This is the suit property 42A. Prayer B is decree for eviction of the same suit property. Prayer C is decree for mean profit. D is mean profit per day. So their primary contention is the primary reliefs they are seeking are decree of declaration in respect of the ownership of the suit property, that they are the owners, and B, my eviction from the suit property. Now your lordship will take page 2, page 11, paragraph 2 of their plaint.
Yes.
On what basis they are seeking for eviction? Your lordship will take paragraph 2. The predecessor in interest of the defendant number 1 and or the defendants and or its members are being unincorporated persons were in unlawful possession of the said suit premises since 25th February 1994. Lordship, there was a deed of lease. Your lordship will take paragraph 4.
This is question is the nature of occupancy is pleaded in
No,
this plaint.
lordship will take paragraph 4, second line. On or about 24th February 1973, there was a deed of lease.
Yes.
So their contention is this deed of lease, paragraph 6 will your lordship will take page 13. I'm showing your lordship the paragraphs relevant. Paragraph 6, first line, on or about 24th February 1994, this deed of lease, which was for 21 years, had expired. So from 1973, 24th February, 21 years of the lease term expired on 24th February 1994. This is the basis that they are asking for eviction. Your lordship will take thereafter. The next paragraph is at paragraph 14, page 19.
Yes.
Paragraph 14, since the defendants were in wrongful possession of the suit premises with effect from 25th February 1994 and 1994.
14, yes.
Paragraph 14.
Yes.
And the said defendants are liable to pay damages or mean profit such and such. Thereafter, your lordship will take various pleadings. The only thing is that from 25th February 1994, I have become an unauthorized occupant or a trespasser as per the plaint case. So your lordship will kindly appreciate, for seeking reliefs under Order 7, Rule 11, I need to treat the plaint case as true and correct. Thereafter, your lordship will take page 23, paragraph 16.
Yes.
It may be stated that after the expiry, your lordship has got it. After the expiry of the lease, the defendant numbers 1 is continuing in wrongful possession under a claim to have its renewal under the terms of its original lease, and to have such renewal, they have filed a suit for specific performance of the alleged contract for renewal. The plaintiff is claiming the right to have a right to recover possession and praying for recovery of possession of the suit premises on the basis of title. The plaintiff states that in spite of the aforesaid proceedings initiated from time to time by various parties, including the plaintiffs and the defendants touching upon the affairs of the said suit property, the instant suit is filed by the plaintiff for the reliefs as sought for herein is maintainable in law, and the plaintiffs are entitled to get a decree against the defendants as sought for herein. Your lordship will take paragraph 18, their main paragraph with respect, their main and only paragraph in the plaint with respect to cause of action. The cause of action in the instant suit arose on 24th February 1994. your lordship will mark it, which is the date of expiry by efflux of time of the lease deed. When the lease deed expired by efflux of time, and since the said defendants were in wrongful possession of the suit property, no part of the plaintiff's case claim in the instant suit is barred by law of limitation. So the cause of action of the plaint, as per the plaint case, to be treated as true and correct, the only cause of action is the expiry of the said lease on 24th February or 25th February 1994 by efflux of time. It is on this basis that they are asking for prayer B. Your lordship will take the next page, the decree for eviction. Because they say on and from 25th February 1994, you are no more entitled to have the possession and you ought to deliver the possession back to the plaintiff. Now, your lordship, therefore, I say that on 25th February 1994, the lease stood determined. There was a determination of lease as per
The efflux of time.
by efflux of time as per section 111A of the Transfer of Property Act. Lordship, I am led by Mr. Gupta. May I take your lordship?
But your lordship is seen from the pleadings in the plaint that, my lord, the plaint case is that the lease expired by efflux of time. After that, there has never been any renewal. My lord, as per section 111A, determination of lease, one of the modes is by efflux of time.
Yes.
Now, kindly takes a look at, my lord, the Limitation Act once. Lordship. Lordship Limitation Act then. But may I hand up a copy to your lordship? My lord? My lord, first your lordship would kindly take a look at section 27.
Yes. Yes.
Extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Now
Yes.
your lordship would kindly take the schedule to the Limitation Act and kindly, my lord, turns over to Article 67. And possibly there would be a flag mark, my lord.
Yes.
Bolo.
By landlord, this is tenancy. Landlord to recover possession.
From a tenant 12 years when the tenancy is determined. So when the time from which
Please, any lesser than
tenancy lease, it's the same thing. Right? So 67, by a landlord to recover possession from a tenant is 12 years when the tenancy is determined. Now your lordship need not be troubled with, I am just reading for my satisfaction, only one, that clause 100, section 111. But the heading of the section 111 is, your lordship, determination of lease.
that is 111 of the TPA.
Yes, of the transfer of property. Huh? Okay, sir. Kindly see the heading of the provision. Determination of lease.
Yes.
A lease of immovable property determines A by efflux of time limited thereby. So, my lord, here possibly, my lord, squarely, this provision would come into effect. Article 67 of the Limitation Act.
Yes.
Now kindly takes a look at the plaint. I'll trouble your lordship with only 3 paragraphs, which my learned junior had already placed, but apropos this, my lord. First is page 11 of my application, paragraph 2 of the plaint.
Page 11. Yes, page 11.
My lord, 2, your lordship would see that the predecessor in interest of the defendant number 1 and or other defendants and or his members are being incorporated persons who were in unlawful possession of the suit premises since 25th February 1994 till the date of institution of the suit.
No,
This
no
is-
allegations that you are occupying as a trespasser.
Yes,
Any allegations?
yes, I'll take your lordship to each and every, my lord. My lord, then kindly turns to, my lord, paragraph 6 at page 13, running page 13, my lord.
Paragraph 6.
Yes. On or about 24th February 1994, the said 21 years period under the deed of lease dated such and such expired by efflux of time. Thereafter kindly comes to, my lord, paragraph 13 at page 19. Paragraph 13 at page 19, my lord.
Ordinate page.
The plaintiffs state that in view of the provisions as contained in the Transfer of Property Act, they also go by that. And in view of the fact that after expiry of the said registered lease, deed of lease by efflux of time, no further renewal or fresh lease is granted in favor of the defendants. The defendants are having an obligation to forthwith make over possession of the suit property to the plaintiffs. Thus, the defendants are having no legal right to retain possession of the suit property.
That is para 13.
Paragraph 13.
Yes.
Kindly also sees paragraph 14.
Yes.
Since the defendants are in wrongful possession of the suit premises with effect from 24th 5th February 1994, the said defendants are liable to pay damages. And thereafter, the last paragraph, which my learned junior had already placed, paragraph 18 at page 23, where they say that I am a trespasser because they've pleaded in wrongful possession of the suit property. Paragraph 18.
Yes.
So your lordship would see that paragraph 18, the only cause of action is in the suit, espoused in the plaint at page 23, is that if the lease deed being expired, having been expired by efflux of time. There's nothing else. There's no other cause of action. Now, apropos this, your lordship would kindly see the reliefs claimed in the suit, the prayers, page 24. My lord, A, decree for declaration that the plaintiffs are the owner of premises number such and such. My lord, I had shown section 27 of the Limitation Act. When that period to recover a property expires, then the title extinguishes. So, my lord, prayer A is ex facie barred by limitation. Now, prayer B, once again, it's barred by limitation. Article 67. Because he does not have any right to recover possession of the suit property. It's beyond 12 years. The suit is instituted in 2009, though we have not been favored with the my lord, affidavit portion of the plaint, so I could not annex that. That possibly would be with the plaintiff. The 12-year period expired in 2006, suit filed in 2009. Then paragraph C is consequential, prayer C is consequential, mean profit. But if I have become the owner, then there is no question of me paying mean profit. D is also mean profit, further mean profit. So your lordship would see that the plaint, that the suit is ex facie barred by limitation. Your lordship need not, there is no triable issue which is involved, which would warrant it to be, the issue of limitation to be relegated to trial on the ground of mixed question of law and fact. But here there is no mixed question of fact, in the sense because as per the plaint case, when the lease deed expired by efflux of time, that is when the cause of action arose. Not factually, my lord, I have nothing else to submit. May I cite
The
to
points of limitation.
only on the point of limit? It's under Order 7, Rule 11D, barred by law. And only on the point of limitation, if I can satisfy your lordship that this is ex facie barred by limitation, then your lordship need not, my lord, relegate the matter to trial, because there is no mixed question of fact and law which is involved in the present circumstances. Going by the plain case, ex facie plain case, I'm not showing any other document, any other pleading, nowhere.
From paragraph 14, I think.
Yes, but paragraph 2 also, because in 2 also he has pleaded his, we are in unlawful possession. But really, paragraphs 2, 6,
14 and 18.
14, 18, yes. 14 and 18, my lord, really seals the issue, in my humble understanding, my lord. Subject to my lord testing it, of course, my lord.
You want to cite any decision?
Yes, my lord, if your lordship kindly permits. Acha copy. This is 2020. This is 2020, volume 9, Supreme Court cases, C93. Your lordship would kindly, my lord, turn to page, internal page, running page 28, which is, my lord, page 420 of the report. Not a good page number to start with, paragraph 37. 37 to 40. May I place it? Has your lordship got it? The full bench of Bombay High Court in a judgment in such and such rightly held that it is well recognized canon of construction of the Limitation Act that where there is a specific article dealing with a specific subject, that article is to be applied in preference to a general and residuary article. The full bench, on examining the, I'm not troubling your lordship with that, because with the first paragraph, kindly comes to the placetum E. Now there can be no doubt that on the determination of the tenancy on such and such, the plaintiff became a tenant at sufferance, if we might make use of the English expression, or a trespasser. Although this possession was originally lawful, and he entered by lawful demise, at the termination of the tenancy, his possession became wrongful and he became a trespasser. Therefore, on the determination of the tenancy, the right would arise in the landlord to recover possession from him of the property, and the period of limitation would be governed by Article 139 of the limitation. This was one of the old act. I'll take your lordship to the newer provisions. Our court almost consistently has taken the view that in a case by a landlord against a tenant, it is Article 139 that applies. The first case which might be looked at is such and such, a decision of Sir Charles Farren, CJ, and Candy J. There at ILR such and such, then the quoted portion, we are inclined to think that the termination of the period of a fixed lease, where nothing further occurs, is the time from which the limitation begins to run against the landlord within the meaning of Article 139 of the Limitation Act. Well, it will kindly come to paragraph 38 thereafter.
Yes.
I'm sorry, my lord, I should be placing the first paragraph at page 421. I'm sorry, my lord, the first paragraph, which is continuation of paragraph 37. The expression where nothing further occurs is obviously with reference to section 116 of the Transfer of Property Act, because it is open for the landlord on the expiration of the tenancy to accept rent from the tenant or otherwise assent to his continuing in possession and thereby create a fresh lease under the provisions of that section. But if the landlord neither accepts rent nor otherwise assents to the continuing of the possession of the tenant, then it is clear that the tenancy expires, limitation begins to run against the landlord under Article 139, and his right to obtain possession from his tenant would be barred after the period of 12 years. Then kindly see paragraph 38. In another judgment by a single bench of Delhi High Court in such and such, it has been held that in terms of section 108Q of the Transfer of Property Act, a lessee continues to be liable to the lessor till possession has been actually restored to the lessor. The continuing possession of the lessee is expressive of the continuing stand that the tenancy in whatever form continues. Then your lordship will kindly skip that. Kindly comes to paragraph 39 at page 422. This is where the Limitation Act 1963 provisions are discussed. Thus, the suit of the plaintiffs, this is a converse situation where the suit was filed within 12 years. But I am drawing the your lordship's attention to the ratio laid down in the judgment. Thus, the suit of the plaintiffs filed within period of 12 years from the determination of the tenancy by efflux of time is within the period of limitation. The defendant has not proved forfeiture of tenancy prior to the expiry of lease period. Mere non-payment of rent does not amount to forfeiture of tenancy. It only confers a right on the landlord to seek possession. The plaintiffs have filed a suit for possession against the defendant on the basis of determination of tenancy. Such suit is governed by Article 67 alone. In view of the above, the suit for possession would not be covered by Article 65, since the specific article, that is Article 67, dealing with right of the lessor to claim possession after determination of tenancy. The appellant plaintiffs have claimed possession from the defendant, alleging him to be the tenant and that he had not handed over the leased property after determination of lease. Therefore, such suit would fall within Article 67 of the Limitation Act. But in the facts of this case, in the judgment, suit was of the Limitation Act 1963.
That is Article 67 applies.
Yes. But I am drawing your lordship's attention to the ratio where the Honorable Court said that in a where there is a determination of lease, Article 67 would apply and the 12-year period would apply. May I cite one more judgment? This is on the court's power under Order 7 Rule 11, qua limitation issue. That the court, if finds the plaint to be expressly barred by limitation, would reject the plaint. May I place paragraph 7 onwards? 7 to 10 I shall be relying upon. 2020-16 SCC 601. 601. May I place it, paragraph 7 onwards? Applying the law laid down by this court in the aforesaid decisions on exercise of powers under Order 711 of the CPC to the facts of the case in hand and the averments in the plaint, we are of the opinion that both the courts below have materially erred in not rejecting the plaint in exercise of powers under Order 711 of CPC. It is required to be noted that it is not in dispute that the gift deed was executed by the original plaintiff himself along with his brother. The deed of gift was registered gift deed. But I'm not troubling your lordship with the facts of that case. Kindly then turns to paragraph 9. Now, so far as the application on behalf of the original plaintiff and even the observations made by the learned trial court as well as High Court that the question with respect to limitation is a mixed question of law and facts, which can be decided only after the parties lead the evidence, is concerned, as observed and held by this court in Shamlal, as well as in Ramprakash Gupta, considering the averments in the plaint, if it is found that the suit is clearly barred by law of limitation, the same can be rejected in exercise of powers under Order 7 Rule 11D of CPC. In view of the above, and for the reasons stated above, we are of the opinion that both the High Court as well as the Learned Trial Court have erred in not exercising the powers under Order 7 Rule 11 CPC and in not rejecting the plaint in exercise of powers under Order 7 Rule 11 CPC. For the reasons stated above, the impugned judgment and order passed by the High Court as well as trial court cannot be sustained and the same deserves to be quashed and set aside. Consequently, the impugned judgment and order passed by such and such as well as passed by Munsif such and such set aside. Consequently, the application submitted by the appellant herein original defendant to reject the plaint under Order 7 Rule 11 CPC is hereby allowed and the plaint in TS number such and such is rejected. So if it is ex facie found to be barred by limitation, the Supreme Court said, it has to be rejected.
Yes, anything
Those
else?
are my submissions.
Yes. Yes, Mr. Doctor.
Let's suit for eviction of a tenant in sufferance is not governed by either Article 66, 67 or 68. It's a continuing law. Number one.
Where you have pleaded that the cause of action continues after the lease expires. Cause of action is continuing till today.
Yes. Even if I don't plead it, under Order 7, at the time of trial, under Order 7, I can lead evidence to show other grounds on which the suit is not barred by limitation. CPC. Order 7, Rule 6.
Yes.
When a suit is instituted after the expiration of the period prescribed by the law of limitation, the plaintiff shall show the ground upon which exemption from such law is claimed, provided that the court may permit the plaintiff to claim exemption from the law of limitation on any ground not set out in the plaint, if such ground is not inconsistent with the grounds set out in the plaint. Now, Millard, I'm sorry.
So this is the ground with regard to exemption. But exemption must be pleaded also in the plaint itself.
Yes, if I have not pleaded or if I have said that no part of the plaintiff's claim is barred by the laws of limitation, it's not that I get deprived from leading evidence to show why my claim is within limitation. That's the reason, Milord. They says it's a question of mixed question of fact and law. It's not never a clear question of Milord. Only law that the court cannot decide. But yes, if I have expressly pleaded limitation, and from that, without going into any other dispute, the court finds that there is no question for going into any disputed questions, or that the plaintiff has made out all his case, all his documents, nothing is to be investigated, then in that event, Milord, the Supreme Court judgment now says that in exceptional cases, Order 7, Rule 11 can be entertained. That is probably one of the judgments which my learned friend has cited.
Your para 18,
My
whether
lord.
your bone of contention is para 18, whether para 18 protects you or not, your paragraph 18.
Milord, your lordship,
Your
that para
contention,
18 will not come under Order 7, Rule 6. I have said that the cause of action in the instant suit arose on 24th of February 1994, when the deed of lease expired by efflux of time. And since the said defendants are still in wrongful possession of the suit property, no part of the plaintiffs in this state is barred by the laws of limitation. Just by not saying that it continues from day to day within the jurisdiction of such and such court, within the jurisdiction of this honorable court, is not a mandatory pleading. B is, Milord, so far as this is concerned, that is still continuing to be in wrongful possession, is good enough in my respectful submission. That in spite of expiry of the lease, his obligation to hand over possession to me is not complied with. But Milord, I am little taken by surprise. Why I tell your lordship, Milord, kindly take the application once. Kindly, Milord, see, if your lordship sees the application, your lordship will find that this is what I was called upon to answer. The defendant is a member of the club, sometimes a 25 Swiss club, such and such. Sometimes in 2009, the plaintiffs have filed the present suit, paragraph 2.
Your lordship need not be troubled with the arguments I made is not born from the application.
Then
Order 7 Rule 11 does not even require an application.
very
If
well.
on the plain it is
Order 7,
expatiate.
Rule 11 does not require an application, and my learned friend says that by coming with the plaint, I can come and say this, then it becomes a preliminary question. If he says that my suit is barred by limitation on the face of it, he has to take a preliminary point. But if he has taken out an Order 7, Rule 11, he will have to come and show to the court that he satisfied any of the grounds under A to F. Now, his attempt, that's the reason I said I was little taken by surprise, because his case is, and now my learned friend says he is not pressing that matter.
No, I'm not saying that. I'm saying
The
that
applicant club, kindly see paragraph 5. The applicant had
he has stated in the written statement.
no, in the written statement, he is just denied it's not barred by limitation. He is not, that would be my third argument.
Yes.
So the case which he has made out in Order 7, Rule 11 is not the case which he has argued before your lordship.
partly argued. Partly argued.
Yes.
Your lordship just see the cursory glance of the application. So paragraph, first 4 paragraphs are
My lord, may I have your lordship's kind leave, my lord?
first 4 paragraphs, my lord, talks of the plaint and the written statement. Then what? Why Article 7 Rule 11? The applicant club had filed a prior suit against the plaintiffs being CS such and such for the following reliefs. So he says, I have filed a prior suit. And these are the reliefs. Leave under Order 1 Rule 8, decree directing the 2 purported deeds of lease so and so and the purported deed of lease dated 19th then to be declared invalid, void, delivered up and cancelled. Declaration that the 2 purported deeds of lease of 1st November 94.
No, if paragraph 5 is relied upon, then that issue has to be framed.
That is what he is saying. That is his
Right.
case. And
Oh.
see, after having said that I have filed a suit, why he says its limitation? Paragraph 6.
Yes.
The plaintiff have sought for a declaration that the deed dated 1st November 94 and the deed of trust are invalid, void, and not binding on the plaintiff. And also claim perpetual injunction restraining the defendant in the suit from claiming any right pursuant to under the said 2 documents. The said CS such and such are contesting the said suit by filing written statement. No counterclaim in the suit has been filed by the defendants. Instead, the said defendants have sought to file the present suit 99, which is ex parte barred by limitation. So limitation is not under order Article 66, 67, 68. He says that the challenge to the trust deed is in a prior suit in which you have not filed a counterclaim. So you knew that so far as my challenge is concerned, that gives you a cause of action to file a suit against me. Now, my lord, with utmost respect, my lord, if you challenge my if you challenge my title, I can defend it. If you succeed, then that's one thing. If you fail, I don't have to file a suit vis-a-vis your suit that no, you have filed a suit challenging my right, therefore I also have to file a suit. The cause of action for declaration doesn't appear that way. The burden is on you. You have taken it on your shoulders to say that the deed of trust is wrong. I'm contesting that. So, on that basis, instead the defendants have sought to file them. The plaintiff has already sought a decree of delivery upon cancellation of the deed of lease and the deed of trust and have claimed a contract. That being so, a claim for declaration ought to have been filed within 3 years. This is a cause of action in Order 7 Rule 11. And I was very surprised.
This cancellation of deed and deed of trust, this is not the plaintiff's case. Paragraph.
This is not the plaintiff's case in this plaint where he's asking.
Yes, we have to confine within this plaint.
Yes. And he
Order
wants
7 Rule 11, we have to confine within the plaint.
absolutely, and he wants
Paragraph 8 and 9 is not the plaintiff's case.
no, and that is not, and that is on that ground only he wants Order 7 Rule 11, not on the ground which he argued. That is why, my lord, I was desperately trying to bring on books, Transfer of Property Act to see where can I meet, because this I was taken by surprise that this is not the case he has made out in the petition.
Anyway, Order 7 Rule 11, the court also have has a discretionary power.
Yes.
Now you have to defend yourself also.
Yes. But the thing is this, my lord, if Order 7 Rule 11 is one of the harshest remedies the plaintiff has to face. So therefore, my lord, the test is ultimate. That under no circumstances can this suit ultimately be heard, and it will be ultimately be dismissed on the ground of limitation.
So where is this? You have not filed your opposition. So written statement could have been produced. What was there in the written statement? This.
My lord, with utmost respect, this is what I am trying to say. The moment your lordship feels the need to look beyond the plaint to ascertain the allegation in the Order 7 Rule 11, my lord, that is not a case under Order 7. Your lordship is now feeling the need, the requirement to go to the plaint in the other suit, the written statement.
Their written statement.
Their written statement. So these things would be evidence which would be considered for the purpose of deciding the point which is troubling your lordship now. His case, my lord, in the order 7 rule 11 is there is a challenge to a document. You knew that the constitution of the trust is under challenge in a suit. You ought to have filed a counterclaim, claiming a declaration then and there. If you have not claimed a declaration there, the declaration which you are claiming in prayer A in the suit is not maintainable. My lord, with utmost respect, my lord, this is probably not the correct proposition of law.
No, these things can be considered. Whether this aspects comes under this aspects come under this order 7 rule 11.
Cannot.
But with regard to your arguments and your averments in the plaint, what is argued by your learned friend?
So far as my learned friend's argument is concerned, order 7 rule 11 purely on the question of
From your plaint,
from my plaint, my lord, as I said to your lordship, my lord, from my plaint, it cannot be argued because of the simple reason I have claimed a declaration not on the basis of his suit. If your lordship sees my plaint, my declaration is on the basis of the averments in paragraph 7. Kindly, my lord, take paragraph 7, which is at page 14.
on the basis of paragraph.
It has nothing to do with he may.
Yes, paragraph 7.
Yes. Kindly see, my lord, at page 14. After, sorry.
Yes.
After expiry of the period of lease on 19 July 97, Mihir Law resigned from the post of sole trustee of the plaintiff number 1. And thereafter, with effect from 28 July 1977, one Bhairu Ratan Pasachia and Dilip Chand Kankaria acted as the joint trustees of the trust estate, who were appointed as trustees of the trust estate on 2nd November 1994 by virtue of the provisions as contained in the deed of trust. Subsequently, on or about 29th August 2002, the plaintiff number 3 was appointed as one of the trustees of the trust estate. Subsequently, Dilip Chand Kankaria resigned upon his resignation. The plaintiff number 4 was appointed as one of the trustees of the plaintiff number 1. Thereafter, Ratan Pachasia resigned, and upon his resignation, plaintiff number 2 was appointed as trustees. Thus, the right, title, and interest of the suit property vested on the plaintiff numbers 2, 3, and 4 as trustees of the plaintiff number 1. By virtue of the provisions as contained in the deed of trust, and are thus the landlords. By virtue of the provisions as contained in the deed of trust dated 24 January 1903, and by necessary implication thereof, the plaintiff, being the owner of the suit property, stepped into the shoes of Mihir Law. In or about 2007, the said Mihir Law died, and it is a matter of record that until his death, the said Mihir Law, being the author of the trust, never terminated and or extinguished the said trust created by him, nor took any legal steps to make the said trust illegal or contrary to the law during his lifetime. Thus, till the death of Mihir Law, and even thereafter till the date of institution of the suit, the plaintiff number was and or is still subsisting as a valid and lawful trust estate. The defendant number 2 is the class 1 heir and legal representative of Mihir Law. The defendant number 2 is the only son of the deceased. Upon the death of Mihir Law, the said defendant number 2 is denying and or interested to deny that the plaintiffs are the owners of the suit property. The defendant number 2 also purported to file a writ application in the High Court at Calcutta, raising objection to the order of mutation of the plaintiff number 1 as owner of the suit property on several untenable grounds, and thereby denied and disputed the right, title, and interest of the plaintiffs over and in respect of the suit property as owner thereof. The denial is such which cannot be compensated by money. She, the plaintiffs, are therefore entitled to claim and is claiming a decree for declaration that the plaintiff is owner of premises number 42. This is the cause of action for my declaration. And it arose in 2007. Number 1. Now, my learned friend says,
your predicament, your legal bar to institute the suit on the expiry of the lease. If there is any legal bar or predicament, then you can get some protection. What prevented you to institute the suit? For example, you acquired the right in this 2007. You have instituted the suit in 2009. So, from the date of expiry of the lease till 2009, if there was some predicament, some legal bar, that can be considered.
Millard,
Because so far your declaration relief is concerned, you are relying upon paragraph 7.
to show, and that is the challenge in the Order 7 Rule 11. Kindly see his application under Order 7 Rule 11. Millard, I am not being called upon, Millard, to answer the question beyond this petition. The challenge is in this petition. Now, Millard, what is troubling your lordship is that why didn't you file a suit in 1994?
No, 1994 is the expiry.
Is the expiry.
2006.
Yes. So, Millard,
If there was any legal predicament in between this period, that is the main question.
Millard, the
To be
trust
decided
came,
at the time of trial.
the trust came into the picture, Millard, so far as the EA is concerned, so far as the predecessor in interest of the defendant number 2 is concerned, who was the author of the trust during his lifetime till 2007 may not have filed a suit. So, if he has not filed a suit and a lessee in wrongful lessee continuing in possession after expiry of the lease is a tenant at sufferance, I need not show any authority before your lordship that he continues as a tenant at sufferance and does not acquire the status of either a person of title because his initial entry to the property was legal. He can never claim adverse possession, nor can he claim any title adverse to that of the landlord.
This trust was for religious purpose, religious and charitable purpose.
That will not I'll have to see. That I don't know.
So your plaint case.
No, that I don't know, but no, Millard, it was a private trust.
Private trust.
Private trust.
Yes.
Now, Millard, kindly come back to Millard paragraph 6, 7, 8, 9, the cause of action in the petition.
Yes.
The plaintiff have sought for a declaration, Millard paragraph 6 that I have placed, the plaintiffs have sought for a declaration that the deed of trust of 1st November 94 and say are invalid and void, not binding on the plaintiff, and also claim perpetual injunction restraining the defendant in the suit from claiming any right, title and interest. The said CS 217 is pending. That is his suit. However, no counterclaim has been filed in the suit by the defendants. Instead, the defendants have sought to file the present suit, which I just now placed paragraph 7. The plaintiffs, this is his cause of action for Order 7 Rule 11. The plaintiffs in CS 217/2005 have already sought for a decree of delivery up and cancellation of the deed of lease dated 1st November 94 and the deed of trust dated 2nd January 1993 and had claimed a contrary title to the plaintiff in CS number 99 of 2009.
See, so far, the plaintiffs in CS 217 are the defendants in this suit.
Yes. So they have claimed, one of the defendants in CS 215 has claimed that no, the plaintiff in CS 99, which is the trust, is not the owner of the property. So there is a title dispute. Now, why Order 7 Rule 11? That being so, a claim for declaration ought to have been filed within a period of 3 years when the right to sue first accrued. So, what he is trying to say is that in the first suit, which I have filed, where I have challenged the deed of trust, in that suit you ought to have filed a counterclaim. Because my challenge to your authority to claim as ownership is before you. Merely by defending that won't do. It was incumbent upon you to file a suit for declaration of ownership. With respect, Millard, as I said, that if you come and say that I am the owner of High Court, I don't have to, the High Court registry doesn't have to file a counter suit on that day saying that no, the High Court is the owner, declaration. He will succeed and fail on his own plate. So if today he comes and says that I have challenged the deed of trust, I am defending it. So where does the question of limitation answer? Where does my question, cause of action arise to claim that had he done any act beyond coming to court, suppose, my lord, he wants to sell off the property today. That would be an act which would have given me a cause of action. But he has come before the court to claim that right. So I am within my limits to challenge it. And this is his cause of action. This is why he says the suit should be barred under limitation. Not under articles
67.
66, 67, 68. That is not his case.
In this Order 7, Rule 11.
Yes. The claim of eviction, then he says, Millard, kindly see. He says declaration is wrong. The claim of eviction of the plaintiff in the suit is consequential upon declaration. Inasmuch as the claim for declaration is ex parte barred by limitation, the other reliefs in the suit is also barred. Where does he say, Millard, that the eviction suit is barred by limitation? He says that the declaration is barred by limitation. And therefore, your eviction suit is a consequential. That is the case in the Order 7, Rule 11. Thus, the plaint filed in the suit is barred by law within the meaning of Order 7, Rule 11D of the Code of Civil Procedure, and the plaint filed the suit is liable to be rejected and in the alternative, the suit to be dismissed. That apart, the present suit is also barred under the provisions of Order 8 of the Code of Civil Procedure, inasmuch as the plaintiff being CS 215 had not filed any counterclaim in CS 217. That is his second ground. That you ought to have filed a counterclaim, you could have filed a separate suit. In those circumstances, evident that 99 is barred by law and the plaintiff is liable to be dismissed. This is all. This is all, Millard. There is no other ground in the Order 7, Rule 11 application.
Regarding Article 67.
There is no other ground. In fact, he has not even taken the ground that the suit is barred by limitation because of Article 66, 67 or 65. He has taken the ground that your declaration under Section 34 of the Specific Relief Act is barred by law and hence the other consequential reliefs are also banned. This is all that I have been called upon to meet.
Yes.
So, Millard, in those circumstances, Millard, the argument that has been made from the bar and the petition that has been filed are, Millard, totally different. So far as the argument made in the petition is concerned, Millard, your lordship will find that the declaration, he is trying to put words into my mind, the declaration on the basis of which he wants me to file a suit and the declaration on the basis of which I have claimed, paragraph 7, are totally different. I may succeed in the lose in the suit, but that's no ground for cause of action or the suit being barred by law. Number one. Number two is, Millard, so far as the relief for limitation is concerned, Millard, this limitation point which he has argued in paragraph 11, Millard, does not hold good because he is not saying that the suit is barred by limitation because it has been filed after 12 years. Even if he is argued so, Millard, even if he is permitted to argue so, Millard, I can show galore of authorities which says that it's a continuing wrong. It is only when you claim a title hostile, then adverse possession. But now the Supreme Court had even gone to the extent of saying that no, if your initial entry to the property was permissible in law, subsequently it cannot turn hostile. That would hit, Millard, Article 116 of the Evidence Act. If your lordship wants, Millard, I don't have the authorities right now, but I can cite those authorities, but they won't be relevant for the purpose of deciding this order,
So
sir.
you can cite them, no problem.
Then
Take
Millard,
the
I'll have to,
citation.
then Millard, I'll have to come back tomorrow morning with all the authorities.
So tomorrow he can reply, or you can come with the authorities.
Yes.
Let him reply
Let him,
tomorrow or Friday.
whenever, Millard, whenever it's convenient to you. Lord.
Yes, record an order.
Friday.
Learned advocate for the petitioner, defendant and learned advocate for the plaintiff opposite party are present. Are learned advocate for the parties. As hearing could not be concluded, let this matter appear on 16/5/2025.
Millard, one, I had a very humble request, Millard, subject to, of course, Millard. Could it be reasonably at the top, Millard?
16/5/2025 at the top of the list.
Reasonably. Because I have a matter fixed, I am arguing so that it doesn't clash. I'll finish this.
The
And,
authorities, or if you will submit some written
no,
note, you
Millard,
can do.
I have an hour because that is fixed at 11:30.
Okay, you cite the authorities, give them some notes, let him reply.
My
একটা বই আছে একটু দেবেন ট্রান্সফার প্রপার্টি একটা আছে
না, দেবো না। হবে না। তুমি একটা কেস মেক আউট করেছো, আরেকটা কেস আর্গিউ করছো। না, ইউ শুড হ্যাভ পয়েন্টেড ইট আউট টু দ্য
দেখে
কোর্ট।
নিন।
তুই না হলে অন্য কেউ আমি ছেড়ে ফেলতাম।
এটা ওনাদের দিয়ে
যখনই বলতে শুরু করলাম আমি তখন করি
আমি তখন
ছেড়ে দিন।
সে যাই হোক, হ্যাঁ রাখো, করতে হবে না বাবা, জয়েন্দা দেখিয়েছে বলে ডিপলি অবলাইজ।
Adjourn motion, item number 4.
So for the petitioner,
For the petitioner plaintiff in the matter.
okay, let it be passed over in the first call.
I think Junior was right outside. Maybe if I can start, then he may join in a while. The junior was just outside, Lordship.
I'm just passing it over.
Yes, Malad. I mean, led by Mr. Sengupta Malad, he is coming.
Okay, let him start. Let us start.
Yes, yes.
I just start. Grateful. Lordship, this application is a 2014 application, Lordship.
Yes.
This suit was filed and a preliminary decree was passed, Lordship. The preliminary decree is at page 36 of the informal paper book, volume 1, Lordship. This is the preliminary decree, Lordship. The informal paper book that was directed to be filed, Lordship. I'll quickly give a background. So,
That is page 36.
Page 36, Lordship. This is the preliminary decree. So, Lordship, here the suit is for partition. Only one property is involved, that is premises such and such. The parties are ad idem regarding their shares in the property. The plaintiff would get 3/4 of it and the defendant 1/4. But the defendant has one condition. He should be allotted the front portion abutting on Srinath Babu Lane, Calcutta, such and such, to which the plaintiff agrees. So, Lordship, in this term, the preliminary decree was passed. Now, Lordship, this preliminary decree was passed by the erstwhile plaintiff, Lordship, who is now the defendant, whose heirs are now the defendant in the suit. Lordship, what had happened is the suit was filed by a single plaintiff and a defendant, Lordship. And then this preliminary decree was passed. A partition commissioner was appointed, and thereafter a surveyor was also appointed. Certain reports were given. These reports were not been agreed upon by the parties. At this juncture, Lordship, the sole plaintiff passes away.
Yes.
Now, Lordship, thereafter, the heirs of this plaintiff does not take any step to incorporate themselves as the plaintiffs in the shoes of their predecessor in interest, Lordship. The suit was abated, Lordship, due to time.
Yes.
Now, Lordship, they started making constructions in violation of this particular preliminary decree. So the defendant lordship had to file an application for setting aside of the abatement and an application for transposition so that he can substitute the heirs of the
defendant.
So accordingly, lordship, that substitution, transposition, and the setting aside of the abatement was allowed by this honorable court. And lordship, now the plaintiff in the suit is basically the original defendant in the suit, lordship. So this application, this preliminary decree was passed on an application by the original plaintiff, lordship, whose heirs are now the defendant. Now, lordship, kindly looks at the application that was filed, lordship. That is at page 24. That starts from page 24, lordship. The relevant part is
Or of the paper book or application?
Paper book, lordship. Application, yes. This was filed by the plaintiff, lordship, and their lordship at page 31, lordship, paragraph 14 of that application, lordship. This is what the plaintiff states on this particular application, lordship. This is the plaintiff's application. The plaintiff states in paragraph 14 that the petitioner is about such an 60 years old at present. The petitioner, in order to buy peace, is presently agreeable to allocate the front portion of the suit premises in favor of the respondent. So this was the particular pleading they had made, based on which this preliminary decree at page 36 was ordered, lordship, directed. Thereafter, lordship, a partitioner commissioner was duly appointed, and lordships, he had filed certain reports. A surveyor valuer was appointed. There were certain disputes that were going on regarding the manner in which the property would be partitioned, lordship. The partition commissioner files a report, lordship, a report scheme 4 that is also there. Now, lordship, this report that was submitted by the partition commissioner was challenged under this application, which is presently before your lordship. In this application, lordship, this is GA 376 of 2014.
After transposition, the defendant
is the plaintiff, lordship.
To the shoes of the plaintiff anyway,
Lordship.
but so far the allotment of shares are concerned, that
It remains the same, lordship. It remains the same.
That means the plaintiff will get 1/4 and the heirs of the deceased plaintiff will get
the rest of.
So that cannot be changed.
That is not changed. That is not in the
So far
challenge.
the present plaintiff,
Yes,
the former defendant, will get the front portion.
The front portion. That is the only point in question. Lordship, this application was filed in 2014 when the plaintiff, the original plaintiff, was also alive. So that time it was filed, lordship. That was challenging the report filed by the partition commissioner regarding the allotment of the positions, lordship. And now, lordship, there were orders passed in this application till before the original plaintiff passed away. Those orders are, lordship, kindly comes to volume 2. Lordship, page 109 of the volume 2 of the informal paper book. So, lordship, during the time when the transposition happened, there was a direction by the court to file these informal paper books. It was filed accordingly. So, this GA 376, lordship, was taken up for hearing on the 10th of February 2014, lordship. And Justice Shamadar, as his lordship then was, he passed on this order, lordship. The commissioner of partition appointed in the matter is directed to prepare a scale plan based on the draft plan being Annexure D at page 84 of the instant application. This is the GA 376, which is before your lordship. The annexure is at page 84 of that application, lordship. That is the annexure we are relying upon. That should be the correct
direction as per 10th February 2014. Okay.
Yes, lordship.
That was also required to be complied with.
Yes. So this was the specific view of his lordship, the Honorable Justice Vishwanath Shamadar, as his lordship then was. So Annexure D, and it was directed on the Landed Partition Commissioner to pass an order in terms of Annexure D of this application, lordship, which is at page 86 of my application. Lordship, kindly takes the GA 376, lordship.
Page 86, that is
84,
paper.
lordship. No, the application. GA 376, page 84, lordship. Annexure D.
Page
84, lordship. 84.
Yes, page
So
84.
this is
That is
the-
the proposed draft
This is
plan.
the proposed draft plan, which according to the erstwhile defendant and now the plaintiff lordship, according to who this would be the plan that is in terms with the preliminary decree that was passed. The front portion of the Srinath Babu lane that is allotted to the defendant to the extent of the 1/4 share, and the rest for the plaintiff in the 3/4 share, as has been shown. And after hearing lordship, this was the direction passed by the Honorable Justice Shamadar, as his lordship then was, that the commissioner appointed such and such is directed to prepare a scaled plan based on the draft plan being annexure D at page 84 of the instant application. Such scaled plan may be submitted before this court within 1 week from the date. That was one date. Lordship, the matter was again taken up on the next date, on the 17th of February. That is at page 110 of the paper book, volume 2, Lordship. It is submitted by the Commissioner of Partition that the surveyor who shall prepare a scale plan is presently out of station. As such, he is praised for time, Lordship. The directions contained in the order dated 10th February 2014 shall be complied with in the meanwhile, Lordship. That is the last line of the order. Now, Lordship, thereafter, before this matter could be further taken up, the sole plaintiff, Lordship,
That is after 17th February 2024.
Yes, after 17th February, even on 17th February, Lordship, the directions contained in order dated 10th February 2014 shall be complied with in the meeting. That was the direction passed by the Honorable Court. But thereafter, before this matter could be further taken up, Lordship, on the 23rd of March 2015, Lordship, the sole plaintiff, Lordship, who is the predecessor in interest of the present defendant's Lordship, passed away. Now, Lordship, there were assurances that we are taking steps to come into the shoes and get ourselves in the suit. And because of this, long time elapsed, Lordship. They did not take any steps, Lordship. The present defendants, who are the heirs, did not take steps, Lordship.
The abatement was set aside. The
Abatement was set
allowed.
aside. Transposition. That order is there, Lordship. Kindly. Allows me a moment, Lordship. Kindly. Lordship, this is page 166 of the paper book, volume 2, Lordship. This was the order passed by the Honorable Justice Sugata Mojumdar on the 17th of January. 166, Lordship, of the paper book, volume 2, Lordship. This is the order passed, which was setting aside of the abatement, the delay, and subsequent transposition and substitution, Lordship. 3 GA applications were filed and necessary orders were executed. This is the GA application.
Anyway, plaint was amended accordingly and
Now the suit is being. Now, Lordship, since 2014, this application was filed in 2014, Lordship. The present situation has changed a lot, Lordship. The partitioner commissioner was served a lot of notices in between, Lordship, when this matter was taken up finally. He chose not to appear, Lordship. Thereafter, Honorable Justice Bibhash Patnaik directed that the matter be contended without his presence, Lordship. As such, they saw the present defendant sought for liberty to file an opposition to this application, 2014 application, Lordship. They filed their opposition. We filed a reply to that. This GS 376 only, Lordship.
yes.
So now, Lordship, the partition commissioner is presently not interested to further come into the suit. The final report, which was filed by the partition commissioner in the final report of scheme 4, Lordship, which is prayed to be set aside.
The
Yes.
final report be discarded.
Yes, Lordship. It not to be taken in cognizance, and it to be prepared in accordance with the annexure D, Lordship. which was also the view of the Honorable Justice Bishwanath Shamadar as his lordship then was, and he recorded such lordship in his orders. In his orders dated 10th February and subsequently again on the 17th of February. Annexure D of this application, lordship, that is at page 84, lordship.
No, page, annexure D is page 34 running.
Page 84, lordship.
Page 84.
Yes,
But you have stated.
The final scheme of partition be prepared and effect on the basis of the plan being annexure D here too.
Page 84.
84, lordship.
Yes, the proposed.
Yes, lordship. This is the proposed plan. Lordship, the 10th February order passed in this application, lordship, where it was stated that such...
Which page is the 10th February order?
That is 109 of the paper book volume 2, lordship.
Yes, 109.
Yes, that's 109 of the paper book volume 2.
Figures you can have. Yes.
The Commissioner of Partition appointed in the instant matter is directed to prepare a scaled plan based on the draft plan bin annexure D at page 84 of the instant application.
So this is not yet done.
Not yet done,
Let
lordship.
this be done.
But lordship, the present partition commissioner is not there, lordship.
Let some other
The
partition
situation inside the property is
appointed.
also changed, lordship. Now they are also objecting to annexure D, lordship.
No, a court order is there.
Lordship.
There is no appeal against this order.
Grateful,
No
lordship.
modification.
Grateful, lordship. They have filed their objection on the point that they are not in consonance with annexure D. I have objected to that in my reply as well, lordship.
Question is whether this order is complied with or
No,
not.
not
10th
yet,
February.
lordship. Not
10th
yet.
February order has to be
10th
complied with.
No, lordship.
It has reached its finality.
Yes, 10th February order has reached its fine. Lordship, even on the 17th of February, it is submitted by the Commissioner of Partition that the surveyor who shall prepare a scale plan is presently out of station. As such, he seeks extension of time to comply with the directions. Considering the prayer made by the Commissioner of Partition, let this matter be adjourned for a fortnight.
So this
The
order is
directions
passed on this application.
on this application, lordship, and it is specifically
It
stated
is
also.
not disposed of. This
Not disposed of.
this interim order is passed.
Lordship, there was even it was specifically directed on the 17th of February again, lordship, the last line, the directions contained in the order dated 10th February 2014 shall be complied with in the meanwhile. So
Well, let me hear the other side.
grateful, lordship.
I have been informed that Mr. Sengupta is returning from DRT.
Okay, let it be fixed on some of the yes.
Yes, ma'am.
Learned advocate for the petitioner. Your petitioner defendant.
I am the present plaintiff, lordship.
That
The
is
transposed plaintiff.
Learned advocate for the petitioner plaintiff is present. Our learned advocate for the petitioner plaintiff. As learned advocate for the defendant could not make his submission today, the matter stands adjourned till 16/5/2025 for further hearing of this application and submission of the defendant opposite party. Yes,
Will
I'm
appear on
keeping it on
16th.
Friday.
Very well.
Grateful, lordship.
Item number 5.
My lord, I appear for the petitioner, defendant petitioner in this application.
Yes.
For the plaintiff.
It was, my lord, heard on the last day. Mr. Shakko Sen, my lord, is leading me. My lord, he started. This is really an application in a defamation suit filed by the plaintiff.
No, today is fixed for what? Filing the reply
No, it's for arguments, my lord.
for further
Because
arguments.
affidavits, yes, affidavits are complete. Yeah, bolbo, no bolbo. My lord, this is really an application for, my lord, production of an original report, my lord, from the registrar of companies. It's a defamation suit where our defense really is, my lord, justification and the truth. And my lord, whatever, my lord, statements or whatever was shown, my lord, in the, my lord, article was based on a particular report
of, my lord, the Deputy Director Inspection, my lord, Registrar of Companies. By this application, we are only, my lord, seeking leave to, my lord, call upon the, my lord, custodian of that document to produce that document before this honorable court. This is the only purpose of this application. I am not, like Mr. Sen had indicated on the last day, we are not, my lord, trying to, my lord, prove that document at this stage. It is only for the purpose of seeking leave to, my lord, call upon the authority concerned to produce the document in a sealed cover. Now, my lord, last day, Mr. Sen was placing reliance upon the written statement which was there in the records. My lord, kindly takes the written statement. What is our defense and why, my lord, this document is necessary to be produced?
Is annexed written statement.
My lord, it's there in the record separately, not annexed.
Yes.
30. My lord, kindly comes to page 13 of the, my lord, written statement.
Yes.
My lord, I just from the top, my lord, after the first 5 lines. Plaintiff's views have been adequately canvassed and addressed in the news item in question, and there can be no doubt that the answering defendants have given sufficient opportunity to plaintiff to place the true facts in perspective. Answering defendants have merely reported the violations of various provisions of the Companies Act by the plaintiff, as mentioned in the inspection report of the Deputy Director Inspection, Registrar of Companies, Kolkata. By doing so, the answering defendants have presented an unbiased, unmotivated story without any intention to harm the plaintiff's reputation. The answering defendants have been extremely fair in their reporting and have also telecast plaintiff's response as soon as it was available. So, my lord, I rely upon this inspection report of the Deputy Director Inspection ROC to, my lord, support the stand or the defense statement in the, my lord, written statement that it is based on a particular, my lord, report. My lord, the other paragraph which I want to show is in page 16 of the written statement, subpara 12.
Yes.
This is only to show why the, my lord, report at this stage is necessary to be called for. Filing of this suit is nothing but a pressurizing tactic adopted by the plaintiff, as the news item telecast was based solely on the inspection report of the Deputy Director Inspection, Registrar of Companies, Kolkata. A news channel is entitled to publish such a report as per the available records of the case. In such a case, if the same is telecast by a news channel, it cannot be said that the news channel is guilty of defamation in any manner. News item was published with a view to see that the viewers of the news channel may come to know the manner in which a big corporation like plaintiff had been flouting laws of the land. It is submitted that without freedom of press, truth cannot be attained. My lord, these are the 2 paragraphs, my lord, I wanted to rely upon from the written statement to justify, my lord, the immediate relief that I am seeking by this application. That is, my lord, an order for production of this document in the form of a report from the, my lord, Registrar of Companies. My lord, I am being led by Mr. Sen. Kindly permits him to, my lord, take over.
We had made our submissions on this aspect only, my lord. The purpose, as I said, my lord, is to have a document produced before this court. Because my defense is based on that. On the only objection coming from the defendant is in the written statement as part of documents relied upon, I have not mentioned. My lord, will that part be material or my body of the written statement will be material? My defense has to be culled out from the body of the written statement. And the body of the written statement specifically refers to my justification of the program is based on contents of that report, which is not a report originating from me. Therefore, I need to produce the original of that report. And for that, I am summoning the office where the report has originated. It is only thereafter when I will try to prove that report, the contents or the existence, then at that stage, my learned friend can raise his objection as regards the admissibility of the document, if at all. Today that stage has not come. Those objections as to admissibility need not be considered at the stage of production of a document. Suppose, my lord, today the document was in my possession and custody. Suppose, in case of any other document, in the case of any other matter, I had wanted to produce that document. Could he have objected? That was the question. On the ground of admissibility. That objection will come later. He will raise it. Court will decide it. Today, I am therefore not required to answer those objections at all. I am only saying that as a matter of course or a matter of right, I can ask a prayer from this court for a direction upon the office where the report has originated to bring and produce this document here. Then that original document will be kept in the custody of this court. At the stage of my evidence, I will call for the appropriate officer to prove this. And then he will be in a position to take inspection also. And why at this stage, at the first available stage, I have come? Because if his witness had been over, he'd been in the box, then he will raise an objection that I am trying to take the witness by surprise or him by surprise because his witness action is over. Today, if he knows and if he has taken inspection of this document, his witness will be in a position, if he wants, to make any comment about the nature of the document, utility of that document, may not be the contents of that document. So therefore, I am coming at the first available opportunity. I am not trying to steal a march over him. In all possible manner, I want to give him a chance so that he wants to say anything, his witness wants to say anything on that, he will have a chance. He will inspect the document. But kindly take their affidavit.
In reply, it is
No. My learned friend, my learned friend has.
last occasion you submitted.
I had made my. I had.
Sen was submitting, then I took leave because I had to leave.
I had just. দেখিয়েছিলাম তো আবার কি দেখো I think I relied upon my lord order 16 rule 6 of the code of civil procedure.
Original site rules to
Yes, order 16, rule 6.
Any person Lordship has got it.
Yes, order 16, rule 6. Yes.
Any person may be summoned to produce a document without being summoned to give evidence. This is what I'm saying. In fact, my prayer is also this. Let him come, produce that document. Document comes to the custody of the court. My learned friend will take inspection. Thereafter, your lordship will see, and any person summoned merely to produce a document shall be deemed to have complied with the summons if he causes such document to be produced instead of attending personally to produce the same. So the office can send it through any other person also. And this production will not have the effect of the document being admitted in evidence. This is made clear. I have not asked for that also. That stage has not come.
No, sometimes in the evidence stage also, witnesses are summoned.
Yes.
Produce some document.
Yes, produce.
That case, he has to be examined.
Here also, that case will arise.
No, not at this stage.
Not at this stage. Because today he is.
So by invoking this provision, witnesses are also summoned.
Yes.
By the parties.
Yes.
To produce documents.
Produce documents.
আর ইন্সপেকশনের সময় একটা পেজ মিসিং ছিল আমাকে তো এমনিও পুরোটা আনতে হবে
এই ফর্মটা দেখিয়ে দাও শুধু নোট হয়ে যে অরিজিনাল সাইড রুলস অলসো এনভিসাজ দিস। এটা জজকে দিয়ে দাও, তোমার কপি আমি লিখেছি।
And if your lordship sees the original side rules, there is a particular form under chapter 8 rule 2, which also mentions about issuance of subpoena.
ওইটাই দিন, মার্ক করা আছে, ওইটাই দিন,
খুলে দিন।
আমি ওটা টিক মার্ক করে দিয়েছি ওইটা।
Kindly see, this is under form number 2, chapter 8 rule 2.
Yes.
Note 5.
The summons which is issued under that, my lord, your lordship will come to see note 5. Should you apprehend your witness will not attend of their own accord, you can have subpoena from this court to compel the attendance of any witness and the production of any document that you have a right to call upon the witness to produce on applying to the court at any time before the trial and on payment to them of the fees and expenses.
আমি তো বলছি এটা।
So before the trial, I am coming and saying that a subpoena may be issued, calling upon the authority to produce this document.
Even আমার prayer B টা দেখো, order directing issuance of subpoena through the concerned department of this honorable court.
I have made the prayer, my lord, in my application also, prayer B, to that effect.
Simply production.
Simply production. Without touching upon my right to prove it at a subsequent stage. I am not saying that this document upon coming here will amount to proof. That stage I will take recourse to after their evidence.
এই চিঠিটা দেখাবে, কেন দেখাচ্ছি? Because ওরা বলেছে তুমি complete setটা দাও,
Yes.
complete set
Now, my lord, I had
26
because, my lord, I could not give them inspection of the entire set of this document. They raised that objection.
Page 26.
If your lordship sees page 26 of my application, this is their advocate's letter,
Yes.
12th of September.
Yes.
Under letter dated 7th September, we have been served with a copy of the inspection report of Deputy Director Inspection. We understand that you will be relying on the said report at the time of hearing of the caption. I don't think, well, there is any dispute about this, that my defense is based on this document. We write to inform you that upon perusal of the report, we find that internal page 11 of the report is not available in the copy served to us. We request you to kindly supply us the complete set of the report. But in aid of this reply,
Now, what was your reply to this?
I filed this application because I have to give them inspection of the entire set of document. I have also annexed a copy of that report here, which shows that the one page is not there. But my application is in response to this reply, which has come. But certain things, well, certain position is admitted from by the parties. If your lordship sees their reply, it is their case that I have a right to rely upon that report. I have given them tried to give them inspection of that report, but the document is not a complete one. So therefore, my lord, how can they object to my asking for the report to come to facilitate that inspection?
Yes.
This is my short submission.
May it please, my lord. Well, my learned friend had begun yesterday or the last day that this is a very innocuous application, but it is not. My lord, the entire case will depend on this document to some extent. So if my lord first sees that the written statement now of my learned friend, which was filed sometime in 2010, 30th July 2010, if I'm not mistaken. 29th June 2010 is the verification date. But they forwarded to us on 30th of July 2010. And at page 12 and 16, if my lord comes to page 16, which my learned friends placed, I'm sorry, page 12 first.
Page 12.
Page, I'm sorry, page 13. Page 13 first.
Yes.
In the middle. So, so just to give your lordship, just before this, to give your lordship a brief history of the matter, NDTV, the news channel, they aired a program on 9th and 10th of February 2010, where it says that ITC, there is a lot of falsification of accounts, fudging of accounts. These words were used, derogatory words were used, and there's accounting malpractice, etc. And then we wrote to them saying that there's no such thing has happened. No authority has ever adjudicated this. But then they again distorted our reply. According to us, that's on the merit. They telecast it repeatedly. Thereafter, my lord, this written statement, we filed the suit for defamation. In the written statement, in page 13, they are saying, the answering defendant have merely reported the violations and various provisions of the Companies Act.
Page 13 of the
written statement. The written statement my learned friend relied on. So they knew about this document even before they aired the program, according to them. February 2010 was the program.
Yes.
So at page 13 in the middle, the portion my learned friends relied on, the answering defendants have merely reported the violations and various provisions of Companies Act by the plaintiff as mentioned in the inspection report of the Deputy Director, Inspection, Registrar of Companies. So this is the first thing they are saying, that they have merely reported. Then the assumption or the implication is that they had a copy of the report as on that date.
On the basis of which they have reported.
On the basis of which they have given. Because our claim is, you have, suppose A defames C, and then B goes on television and says that A has said this about C. C can sue B also. You're republishing that. So first, without making any independent inquiry, their defense, my lord, is that, yes, we have aired this program, we have used this language, fudging accounts, malpractice, etc. But we have merely done so on the basis of a report. So the assumption is they had this report with them from the beginning.
That is the bone of contention.
Yes, it's the plinth of their defense, because their defense is fair comment. It's not a denial of using the defamatory words or airing the program. So their defense is fair comment, that they are entitled to make a fair comment.
No, if they have relied on the report, they are justifying the same. The plaintiff, the
yes,
are justifying the same.
So in 2010, when they aired the program, they had a copy of the report.
Yes.
So now they can prove that copy which they had. Or if it is, like my learned friend hasn't said that it's a public document. If it was a public document, then they could have got a certified copy. There are many ways for that he can prove his case. But this application is to stall my hearing and to fish out evidence. Now this report, if they had this report with them, whatever copy, secondary evidence they can give. So they don't do so. Now your lordship will come to, just while we are at the written statement, page 16, which was also placed. Filing this suit, my lord has it, page 16, paragraph, subparagraph 12, is nothing but a pressurizing tactic adopted by the plaintiff, as the news item telecast was based solely on the inspection report of the Deputy Director. So they are saying it is based only on that. My learned friend even went to the extent to say not a word more, not a word less. And even in the copy of the report that they've annexed, this word of falsification, fudging of accounts, malpractice, these are not used. They have the inspection is made. There are possible contraventions of these sections. After that inspection, there's a proper show cause given, adjudication is made. A lot of things happen. This report was of December, and they telecast this program in February. And by that time, they have not proved that
2009.
2009, yes. So then, now my lord will just finish with this page 16, which that portion was placed, and the next paragraph or next sentence was also placed. The news item was published with a view to see that the viewers of a news channel may come to know the manner in which a big corporation like the plaintiff has been flouting the laws of the land. Page 16. Page 16 of the written statement, my lord.
Yes.
Of the written
Yes,
statement.
page 16.
Your lordship has seen what the language is, that the big corporation like the plaintiff has been flouting the laws of the land. So this is their case. An inspection report does not amount to a breach of law. It has to be adjudicated. There has to be some judgment. There has to be some proceedings taken against me. Nothing they have proved. They just got at the beginning that someone had inspected. So, and now your lordship will turn over the page at the contradictory stand taken. This is not so important for this application, but I need to show, my lord. Page 17, the third sentence of the first paragraph on page 17. The present plaint is a blatant attempt to conjure up a defense and launch a counterblast action when in fact no improper aspersion has been cast on the plaintiff. So they are saying that we have not cast any improper aspersion on you. And yet, the paragraph before, they say the public needs to know that this big company is flouting the laws of the land. So it's contradictory. But my point as far as this application is concerned, they had knowledge of this document, it seems. If they didn't have knowledge, their case will fall. Now, that is why I'm saying it's a vital, if a document is so important, then they'll wait for 15 years then to disclose this document. Now, my lord will come to the end of the written statement, which is the list that is required under law to be given of documents relied upon and where these documents are. My lord, after the verification, your lordship has page 56 is the verification. The gentleman who affirms the written statement, verifies the written statement, is a constituted attorney. But he says everything that he has said is true to his knowledge. That's another point that will be taken later. Now, your lordship turns over the page 58. Documents relied on by the defendant, nil. Documents produced with the written statement, nil. Documents annexed with the written statement, there is 2 emails. The email that I sent them saying that these things, the allegations are false, you should not make them and stop these telecasts, and their reply. They're 2 emails. They are admitted documents. So they have chosen, they have not relied upon this document. They have not produced the document with the plaint, nor have they annexed it with the plaint.
A written statement.
With a written statement. Now, if my lord comes to order 8 of the Code of Civil Procedure. Your lordship has. Order 8, Rule 2, my lord comes.
Yes.
Not 2. Rule 1. How is it different? My lord, give me 1 minute. Hmm? Hmm. My lord has yes, Rule 5. My lord, order rate, Rule 5.
Yes.
I'm sorry, my lord. Order rate, Rule 5. Every allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading, shall be taken to be admitted, except as against the person under disability. লিস্টটা কোথায় দেখলি? No, it's under which rule? কি? কি আশ্চর্য! What is this? Is it a What is article?
This is rule.
No, এটা কি? Yes, yeah. Well, I'm really sorry. Well, if your lordship comes to order rate, Rule 1 first. Rule 1. The defendant shall within 30 days from the date of service present the written statement of his defense. Then my lord will come to Rule 1A.
Yes.
Your lordship has that? Because my amendment was not showing.
So it was 1999, this amendment.
99, with effect from 2002.
2002.
1 capital A. Sorry. Duty of defendant to produce documents upon which relief is claimed or relied upon by him. So he has relied upon this document in his written statement. It is his duty to disclose this document. Where the defendant bases his defense upon a document or relies upon any document in his possession or power in support of his defense or claim of set-off or counterclaim, he shall enter such document in a list and shall produce it in court when the written statement is presented by him, and shall file at the same time, deliver the document and a copy thereof to be filed with the written statement. Manoj, they have relied on this document, nil, according to them. They are not relying as per the list. Then 2, whereas any such document is not in the possession or power of the defendant, he shall, wherever possible, state in whose possession or power it is. He hasn't stated that this document is not in my possession. So the assumption is that he had a copy of the document with him. So he could have produced it, but he chose not to produce it. So 2. Then 3, a document which ought to be produced in court by the defendant under this rule, but is not produced, shall not, without the leave of court, be received in evidence on his behalf at the hearing of the suit. They have not sought this leave from my lord to rely on this document. In the prayers, they have asked for production of a document. They have not asked for this leave, so they are not entitled under this order rate Rule 1A3. They are not entitled. Then 4 is nothing in this rule shall apply to documents produced for cross-examination or handed to the witness to refresh his memory. That's when my witness goes, they can't show me this document. It's not my document. So this is the main objection we took. In the written statement, they have flouted this rule, and this is a specific prohibition under the CPC that they cannot produce this document without the leave of court. Leave has not been sought. Now, next, my lord, order 13, my lord will see. Okay, well, let's hope. Order 13 is for production of documents. It relates to documents. Rule? Yeah, the affidavit of documents. And order 13 says, original rule 1, or original documents to be produced at or before the settlement of issues. Issues have long been settled in our suit. Now, the parties or their pleader shall produce on or before the settlement of issues all the documentary evidence in original where the copies thereof have been filed along with the plaint or written statement. The court shall receive the documents so produced, provided they are accompanied by an accurate list thereof, prepared in such form as the High Court directs. Nothing in this sub-rule shall apply to documents produced for cross-examination and to refresh memories. So they are under an obligation before the settlement of issues. Issues have been settled, and to produce these documents. So what this really in practice amounts to is the affidavit of documents. Your Lordship knows in a suit both parties file their affidavit of documents first, and there it is written in the 3 paragraphs. These are the documents I have in my possession. These are the documents I have copies of. The possession is with so and so. I don't have it. And then you can give a notice to produce if it's with the other party. Suppose the defendant is producing a document, original letter is with me, the plaintiff, he can give a notice to produce, to give. So in that affidavit,
also, the issues are not yet framed.
Framed.
Issues are framed.
Framed long ago. I'll give them the date. Yeah, they've annexed the order also. So again, in violation of this rule, this document is trying to be slipped in. So my lord will see the affidavit of documents for that.
No,
They have
your
affirmed.
record at page 26, it was given prior to the framing of issues. Your
No,
letter-
much later. At page 26 is replied to page 25. I'm coming to that. Bits and pieces can't be shown. That's why I've started from the beginning. What is the law on this? First, nothing has been addressed by my learned friends as to why they didn't give it in the written statement under order 8 they are required. Why didn't they produce it? Now, my lord will see from the suit records, there is an affidavit of documents affirmed on 16th of November 2022. My lord will make that note to defendant affidavit of documents to by one এটা কি ওদের না আমাদের Nikhil Guliani? Yeah. Nikhil Guliani. Where? Yeah, it's with them, no? It will be there, the affidavit of documents. November 22. না খায়তানের না ওদের NDTV একুইলগ এরকমই একটা হবে। You have a copy? Give it to the judge. My lord will use my copy for the meantime. ওদের একটা কপি দিল তোমার আছে? The cause title is huge. If my lord comes to page 6 of that document, আমারটা দিয়ে দিচ্ছি।
Page 6.
Page 6. I, Nikhil Guliani, etc. I am the head legal, paragraph 1, paragraph 2. The defendant number 1 had in its possession and power the documents relating to the matter in question in this suit, as set out in the first and second parts of the first schedule. The defendant objects to produce the said documents in the second part, inasmuch as it consists of cause papers in the suit and contains confidential communications between the defendant and advocate. To the best of my knowledge and information, the defendant has not known and had never in its possession or custody or in possession of custody of its pleader and agent or in possession of custody, etc. in the books of any such document or other documents relating to the matter in the suit, or any of them wherein the entry made may be relative to matters, or any of them other than except mentioned in the first schedule. Then the first schedule, my lord will see page 7, only 3 documents. So they are saying they have these 3 documents in their possession. Second part, they don't need to disclose the cause papers and confidential information. They don't refer to this report at all. This is in the year 2022, 12 years after their written statement. You'll also will see page 7 and make a mark that in the schedules of the documents, they could have easily said here, we are relying on a document on the basis of which our defense is there, but that is not in my possession. Or they could have said, I have a photocopy of that document, I will disclose that document. They never did so. So again, they are not permitted to do so. after this without leave of court. Now they have to ask for leave of court. Now what happened is, after the documents were disclosed and the written statement was filed, then the issues were framed on, my lord, page 20 of the my learned friend's petition, my lord, will come, page 20. First of February 2023.
Page 20.
20.
Of the application.
20 of the application. Now, counsel for the respective parties are present. They have filed their suggested issues, and these are the issues. So what the issues are, we are not discussing right now, my lord, but the fact is, before this issue, they were to file their affidavit, their documents. Then, my lord, will see the page 21, what the directions are. Page 21 of the application. Counsel for the plaintiff prays for time to file the judge's brief of documents. Let it be filed within 3 weeks. Counsel for defendant prays for inspection of document of plaintiff. Inspection carried out within a week. And after inspection, plaintiff is directed to file the brief of documents. So that is done. Then, if my lord keeps turning to page 25. So, my lord, in the month of February, the issues are settled. From time to time, the parties took time. Page 25. 7th September 2023, a letter of the defendant. Dear sir, enclosed find a copy of the inspection report. After all this has happened, a copy of the inspection report of the deputy director, which we shall rely upon at the time of hearing. Inspection of the same can be taken on 8th September at 4:30 in our office. So they disclose. My learned friend only places the next answer to that, saying, I have admitted this document. Now, my lord, will see that they chose to, by letter in a suit, my lord, usually we can disclose a document by a letter. It can be done. So they say, we are going to rely on this document, come and take inspection. But under the order 8 and under order 13, they have to first get leave of court to take to rely on a new document. In a commercial suit, now it's very strict. You probably cannot this thing, but before it we were not that stringent, my lord. The laws, it could be allowed, but you have to follow the procedure and ask for leave. Now look at our reply. That's later. That's the next day. Yeah,
Applies in 26.
So page 25 was on 7th September.
Yes, they are
then there's a, if my lord comes back to page 18, there's a date just to keep the chronology. That was on 7th. Then on page 18, they come before the court on 8th September. And then they say that they want to file. Now, my lord, will come page 18. That's 8th of September. Counsel for the plaintiff has filed admission denial. Let the same be kept on record. Counsel for defendant submits. Defendant has prepared affidavit for admission and denial. It is under affirmation. So they are still doing that. Then, counsel for defendants further submit. They have disclosed another additional document and served a copy of the same to the plaintiff. Plaintiff is at liberty to take inspection of that document. No leave is sought. It merely says we are giving inspection. Then formally they'll have to ask for leave, and they are relying on a document of which a copy they are giving us. So this is not the document that's
no
being...
leave is sought.
No leave is sought. No leave is given also.
No, in order dated September 8, 2023, nothing is mentioned with regard to leave.
No. So they've just mentioned that we've got another document, let them take inspection. Now, then we took inspection. Now your lordship will come back to 26. Now we'll come to 26. They sent us a copy of a photocopy of the document. And we were to go and take inspection. Now, from the photocopy, this is our reaction to the photocopy, page 26, which is on 12th September. So 7th September, they write. 8th September, they tell the court, we are going to file an additional document. Then on, let them take inspection. So 12th of September,
So
then
that
I
was
write.
oral submission or written application? That
Oral.
September 8th, oral submission.
Oral submission. Yes, this is on the basis of this letter that they gave at 25. Then, my lord, will come to. This is my point that I'm making, my lord, is the document they want to, that additional document they want to rely on is not the document that's coming today from the registrar's office, which they want. It is a photocopy of a document, whatever it's worth. Secondary evidence they can give, whatever it's worth. Now, my lord will see page 26. What was our response to the photocopy they sent us? Under the letter of 7 September, we have been served with a copy of the inspection report of Deputy Director. We understand that you will be relying on the said report at the time of hearing of the caption suit. We write to inform you that on the perusal of the report, we find that internal page 11 of the said report is not available in the copy served to us. Therefore, we request you to kindly supply us the complete set of the report. Upon receipt of the complete set of the documents being relied upon by you, we shall take inspection of the original report with prior notice to you in terms of the order dated such and such. So what happens, my lord? Usually inspection is given of the original documents. Now they say that this is the photocopy I'm sending. I don't know that whether they have an original with them or they have the photocopy with them. They have sent me a photocopy, an incomplete set. Once I bring it to their notice that one of the pages is missing, so this report, so you give me the full set and I will take inspection of the original. Then they file this application. And now they are asking for, so I would say this document that is at Annexure G from page 27 onwards, this is the huge document which they want production of. And my objection is, you prove your case. You don't get the court to get you the documents. G, page 27 to page 89 of the, is this inspection report.
27 to 89.
To 89 is this inspection report which they want to rely on. Not 89 maybe.
Yes, this is sought to be relied.
This is sought to be relied on. Now, they have not taken leave, my first point. Order 8, they have not mentioned it in the written statement, though their case is that they made the broadcast only on the basis of this. Solely, the word they use in the pleadings. And not a word more or not a word less in the submissions is used. So they want to rely on this document. Very well, then you take leave and you rely on this document. And if you can't, if you don't have the original with you, you find out how to get the original, but you can't ask for the blessings of the court even before disclosing. And that order, which was a Rule 3, Order 8, Rule 1A, Sub Rule 3, they have to ask for that leave. They haven't got. So now they are trying to disclose a third, another document, a second document. They rely on this because they say this is what is with us. They are admitting that they don't have the original. They are saying they rely on this. Then when their turn comes to prove, if this leave was given, which is not given, when their turn comes to prove, they will prove the photocopy that this is the copy that somebody gave me. They are not disclosing their source at all in the written statement. Where did they get this copy? It's an internal document. It's something very private, and if it goes, if you take it out of context, it's obviously defamatory. So now they have not proved, if they have not argued at least, so that this is
26 to
27 to the end. Yes. So it's and there the page 11 is missing. Your Lordship will see at page 38, your Lordship will, I'm sorry, page 37. My Lord will come to page 37. On top is written the internal page 10. And at page 38, the internal page is 12. So we don't know what was there. Maybe there's others are missing. We have not been favored with the full copy of it. This was exactly what was given to us.
Page 37.
Page 37. On the top, my lord will see internal page 10.
So the prior page.
And the next page, page 38. Your lordship will see internal page 12. So this document is incomplete. Now they stop at that. They say that I want to rely on this additional document. Court says give them inspection. They fail to give us inspection. Even of this incomplete document, they sent us a photocopy. There's no question of taking any more inspection because they are saying that they don't have the original. Now an application is made. After that, so that was September. Then this application is made in November. And now see the prayers, my lord, at page 15.
Yes.
An order be passed directing the registrar of companies to depute a competent officer for production of the original report of such and such to produce before this honorable court. Then no leave of taken to rely on this document, nothing. They just want a direction on the registrar. He'll come and bring all the documents they desire. Then B, alternatively, an order directing the issuance of summons or subpoena through the concerned department for production of the original report before this honorable court, etc. So prayer B, now the subtlety that is there in my learned friend's argument, he relies on order 16, rule 6. My lord comes to order 16. My lord comes to the first part of order 16. What is it about? Order 16 is about summoning and attendance of witnesses. It's not about production of documents. Order 16 relates to witnesses. Like there are different types of witnesses and you can summon the witnesses. Now, order 16, rule 6 says if you are calling a witness only for the sake of production of a document, you need not cross-examine him. Order 16, rule 6.
Yes. That means at the evidence stage.
At the evidence stage, you are calling a witness. This is a particular, this is order 16, rule 6 does not give leave to a party to produce a document where, as and when they please, in violation of order 8, in violation of order 13.
The 16 rules.
Rule 6.
At the time of evidence.
Yes, that is at the time of evidence, but the point is, what at the time of evidence? At the time of evidence, you are calling a witness. Now, this is a particular type of witness in order 16, rule 6. He is a witness who producing documents. So we don't cross-examine him. He comes, a subpoena is issued by the court. No leave of court is required to call this witness. Or if you want a subpoena to get a document, you can get. But that document has to be on record if you want to prove that. A brand new document, often, unless it is in cross-examination or to refresh the memory. Suppose a person says, no, I have not sold the house. I can get the registered copy of the conveyance from the registrar of conveyances and confront him, is this your signature? Is this your document? And that I can take him by surprise during cross-examination. Not before. The idea is not, now this summons is to a summons for a witness bringing a document. Any person may be summoned to produce a document without being summoned to give evidence.
So that documents can be proved by the maker itself. Suppose somebody has prepared a report, unless it is a public document.
Then he'll have to call him as a normal witness.
So it is he who can prove that document.
Yes.
That is the maker of the document.
Yes. So that is a separate person. The registrar today will probably be not the same registrar who was there in 2010.
He can say from his office record.
Yes, he can send it. This is the document that is lying with us.
Yes, he will not have any personal knowledge.
But this is not the provision for producing a new document. This order 16 relates to the nature of the witness. For that, they have to take leave under order 13. leave to rely on a new document. We are at the production stage. They have produced their documents. They have not relied on it, even though in the written statement it is clear they had a copy of the document. Now, your lordship will see what's the admission being made by my learned friends in this application. So this is to do any person may be summoned to produce a document. But can you produce any and every document you please in a suit? In a civil suit, you have to disclose your documents from before. There's no element of surprise.
Documents are concerned, yes. So
No element of surprise.
Yes, summoning a person is concerned, it is provided.
Yes. So if but that doesn't justify the document, I can't ask for any and every document which is a public record. I can't
Unless
ask.
it is relied upon.
Unless it's relevant, it is relied upon. I've said it's relied upon. So my learned friend brushed it aside. He said, I've said it in my written statement. I rely on this document. And then why wasn't it disclosed with the list? Why wasn't it disclosed 12 years later with the affidavit of evidence? Then if it is a public document or not, that will be, like my learned friend fairly said, if that document comes, the admissibility of that document will be another issue. It's a report relating to a sensitive inspection of somebody's accounts. That inspection comes. If it was an order passed eventually by the appropriate authority, the company law board or the registrar passes an order that yes, we have been held that you are guilty of this offense, and under the Companies Act, you have to do X, Y, Z, imprisonment, fine, whatever there is. That hasn't happened. That's another matter. That's in the merits. They could have produced that. But this is just an inspection report. After this, a show cause is issued. Then I'm answered that show cause. Then there's an adjudication. Then there's a finding. All that is absent. So they have jumped the gun. As soon as they've got this report, they have published. Because a big corporation flouting the laws will attract eyeballs, basically.
Anyway, that is a matter of trial.
Yes, that is a matter of trial. So now that is why I'm saying, so if this is an admission that they did not have this document or the complete document with them, it's going to really destroy their defense. And that is what they're trying to fill up a lacuna. And they're trying to get this document by fishing it out from the public records, etc. So if they want to rely on any document, there was a time and place to do so. And now they have, at the most, they have said by a letter, we will go and want to rely on this photocopy.
Actually, Order 8 is the specific provision.
That is violated in 2010.
No, Order 8.
8. And then Order 13. Rule 1, leave is required if they don't.
No, Order 13, yes.
Order 13, didn't I read? I read it out, I think. Rule 1.
Yes, no, Order 8 is with regard
Yes,
to
Order 8, the leave is required.
Order 8.
Order 8, Rule 1,
Order
capital A,
Production.
3.
So this
31.
provision is not clear with regard to production of documents.
No, if you need to produce a document, you can do so by calling a witness, by issuing summons. The summons is on the witness. You so-and-so, please produce this document lying in your custody here. But if you want to rely on that document, there are certain things you have to do as a precondition.
That is Order 8.
Order 8 and Order 13.
16 gives lays down the procedure.
About the witness.
About the witness who is to produce the
Yes,
document.
about-
But so far the document is concerned.
Yes.
Order 8.
Yes.
And Order 13 also.
Order 13 is for production of documents. That's why I
That is
spaced
the
it.
stage of production.
Now that the reason for the title of the order is important. Order 13 is for production, impounding and return of documents. So it's for production of documents. Order 8 is for written statement. In the written statement, you're bound to give this list. And if you haven't given this list, only if the court gives you leave, you can rely on a document. That leave has not been taken yet. Now, they just simply say, I want to rely on this new document after the issues have been framed. Not before, after the issues have been framed. Issues were framed in February.
In your reply, did you object that?
No, I said that you give me inspection, but the copy you've given me is incomplete. Then they couldn't find the complete copy with them as they've annexed it themselves. It's an incomplete.
Just sought an inspection, not objection. You did not.
I
object.
didn't seek inspection. They asked me to take inspection.
No, but you wanted the entire.
Yes, I said I'll take an inspection if you have the entire document.
Hereafter, you will decide whether to object or not to object.
Yes, the admissibility of it is a different matter. But I haven't even taken inspection. I wouldn't know what document he's giving.
Because you see, leave has not yet been obtained, but
True.
the same has been.
There's no admission on my part. If they want to rely on a document, they had a lot of opportunities to do so. Now, they want to rely on this document, which is at page 27.
Yes.
Now, is the document which is coming from the registrar the same document? No. It will be some other document with, it'll have another page. It'll physically be another document. And if they want to prove that this was, they have to prove they had this in their custody. And on the basis of this, they have made the program. On the basis of this, they have a defense to my claim. Now, it's their very foundation. It's not something just that's a subsequent event has happened. I couldn't produce it before there's any cause. This is their case. It just proves that they didn't have the complete document with them. For all it's worth, they didn't do an independent inquiry. They just published it recklessly, the story.
Now we have to confine ourselves with regard to the right of producing
the technical this thing that why haven't they produced? And you cannot get the assistance. So what happens? Documents, my lord, I also wouldn't have. It's a technical thing. Everyone wants to get to the truth of the matter. So documents ultimately are liberal. The courts are liberal about it. But even at the stage of appeal, the Order 41, Rule 27, documents can be given. But there is certain criteria that have to be fulfilled. Otherwise, what the courts have said is there will be no end to litigation. If every time I pull out a document, and my learned friends' arguments are very, seems innocuous. I am being so fair to them. I'm showing him this document. So when my witness goes, he'll show my witness the document and prove it through my witness. They have relied on it. My witness is not going to see the document only. At least we will not permit him to see it till leave is given.
They are not the maker of the document.
They are not. So in cross-examination, he can't confront him with that document.
If he does not have any knowledge, he will say that I don't have any knowledge.
No, but that is the attempt will be made that he might have knowledge. Now, this document is there. There might be subsequent proceedings. He might have knowledge. That's another matter.
Now his right to produce only.
His right to produce an additional document. And as far as the original is concerned, when they gave us a copy of the document and when they said we are going to rely on this copy, they never said that they didn't have the original. There is a specific provision in Order 8 that if you don't have, or in that affidavit of assets that I read out, that's the standard format. This document I want to rely on, but it is not in my custody. You mention it, therefore I'm not able to produce it. But they apparently had this photocopy. Where did they get this? This is the main question that they are trying to avoid is, where did they get this document? They are not a party to that inspection. They are not the registrars. So this idea that, and this application is an admission by them that they never had the original document or they never seen the complete set of documents. So it's very important that whichever way your lordship decides, these reservations must be the right that has vested on the plaintiff by making this application. The fact that they never had the complete set of documents at the time when they published the program. So their program, and they have said that we have not said a word more, nothing less. We have solely relied on this. Now we'll have to see from this report, are the words malpractice, flouting the laws, all these there. And in the written statement I showed, my lord, it's contradictory. One place they are saying that we need to show the press that they are flouting the law. Next paragraph they're saying we don't have any improper motive. We are just reporting as an independent news agency, which is creditable that if they do so, but they have to make some minuscule also independent inquiry. Is this a fact? If someone says that, no, your house is encroaching on the footpath, there's a show cause, you show that, and it's not, and you have the title deeds eventually. Then it's not. Then you cannot run an advertisement program, public program, after 3 months saying that, oh, he has encroached onto public property. So it's just an enquiry was made at that stage. They have not even now, right up to 2025, all this application, they have not asked to produce the order
No, their bone of contention is the report. Their ground of the
report. And there are
the
many
defense.
ways to get it. I can say it like it's not a hide and seek. They can get a certified copy. They can do a RTI. They could have done million things, but without due diligence, even that's the case I'm going to show. 3 cases I'll rely on, my lord. One is a order 47, rule 27. That's at a much later stage. But the court says it's not an endless process. You have to show that despite due diligence, you were not able to produce the document. In 2010, you have this document, and allegedly, and you take 2022, whatever reason the suit has dragged on for so long, you give your affidavit documents, even then you don't get it. And now when my witness is going in the box, so that has to be a criteria that why are they doing it now? And it's not simply for the asking. Now, the one more passage my learned friend showed was from the original side rules. This is the form of the summons, the form. And in the form, it is written, I'll just show. I think it was chapter. Chapter 8, well, yes. No, the form ta kothay ache? Where is the form? And my lord, form 2.
Yes.
Form 2, note 5. Note 5, your lordship will see. Should you apprehend your witness will not attend on their own accord, you have to subpoena from this court. You can have subpoena from this court to compel the attendance of any witness and the production of any document. Now, this is the important part, that you have a right to call upon this witness to produce on applying to the court at any time before the trial. My witness was in the box literally that day when they moved the application. And payment to them of fees and expenses prescribed. So you have to only, if you have a right to call upon the witness to produce a document.
Upon obtaining leave from the court.
Yes. On applying to the court at any time before the trial, then only you can ask for this production. And this document which will come from the registrar, if it is a public document, they could have got hold of it. It's not that they couldn't have got hold of it. That's the point. The fact is that they have got hold of a photocopy, an incomplete version, and they have jumped the gun and they have made this great news, breaking news or whatever it is, splash, and then only after we filed the suit, they stopped. Immediately they stopped. They haven't done anything for the last 15 years. We tried to get it settled, but it didn't happen. Because it's not for the money, it's for the principle that we are fighting. Because it's a big thing. We are a big company. One of the shares will be affected and shareholders would have been affected very seriously. Still, there's telecast for quite a number of days. And many telecasts. So, Damala, I want to show 2 other judgments, my lord, if another day.
Better both of you submit written notes of arguments. You reply.
No, we'll give.
But let
both
my
the judgments as well as your written notes.
but I will have to deal with his points, my lord.
You deal it with in your written notes.
No,
Whatever.
We'll give a note.
Time also, I will prepare a note.
No, reply. You see, you cannot add anything new. Only
We'll deal with my note, with my law points.
Law points, I
I'll
will
give
have to deal
I have 3 judgments.
reply. Then come on Friday.
Well,
next week.
Keep it after reopening. Man. We'll come back with a note at the 3 decisions.
After reopening.
1 week after due.
Oh, my lord, may I take back my affidavit of documents that the original has been given to my lord. Amar copy to this.
So take back your copy. Original is there. Yes, record and order.
Thank
The original set.
Thanks.
Counsels for the parties that present. Learned counsels. As the hearing could not be concluded, the matter stands adjourned after vacation.
Yes.
Matter stands adjourned till
8th 9th
16 6/2025.
And we shall bring notes on that day.
Yes, yes, you will reply and you submit notes. Okay, 16th of June.
Great.
My lord, before your lordship rise, my lord,
The copy of the judgments from my learned friend, then I can reply on the same day.
Okay, better.
Judgment is citation, I will reply on the
Okay,
same day.
better you reply and if possible, you submit on the same day or within 1 or 2 days.
Yes.
my lord, before your lordship rises, may I have your lordship's leave to mention, my lord, the item number 6, that is the next matter. Your lordship will be probably taking up at 2 p.m., my lord. I am in some difficulty today, my lord. If your lordship kindly takes it up on Friday, my lord.
Not Friday, then Monday, my lord.
Monday, my lord.
Okay, item 6.
My lord, 6.
Okay, let it
Next
be.
matter.
Let it be not this week.
Very well.
My lord, my lord. Grateful.
সোমবার হবে একবার বসে নিও আমার সাথে ওই আমার এই অ্যাপ্লিকেশনের কপিটা দরকার
এটা তো হ্যাঁ
Will it be my lord's pleasure? Well, since we've been waiting, that my lord will take it up on this on Monday, my lord. Because if it goes down in the list, my lord, it will never be taken up, and the last week is a urgent week.
Okay, item number 6.
Number 6.
Record an order. Let item number learned advocates for the learned counsels for the parties are present on the prayer of learned advocate for the opposite party.
Yes.
My lord, I am for the 6, 7, 8. Respond number 6, 7, and 8, my lord.
Opposite party number 6, 7, and 8.
I am for 1 and 4. Defendant number 1 and 4.
The matter stands adjourned till 19/5/2025. Let this matter appear on the said date within the first 10 matters.
Very
Grateful, my lord. Grateful.
এই অ্যাপ্লিকেশনে ম্যাটার আছে নাকি আমিরুল আমাদের 2 PM আছে দাদা সেটা জানি না অরিজিনাল প্রিন্টেড হ্যাঁ সিঙ্গেল এই অ্যাপ্লিকেশন আছে না
না আচ্ছা খুঁজছি প্লেন্টিভ রেসপন্ডেন্ট আইটেম 5 হ্যাঁ হ্যাঁ 7 পার্টি হ্যাঁ 60 হ্যাঁ কোন অ্যাকাউন্ট নাম্বার করতে হবে কেন ও তোমার আমার অ্যাকাউন্টে টাকাটা পাঠিয়ে দিচ্ছে নাহলে ইয়েতে পাঠিয়ে দিক না
ওই আমাদের এডমিশন অ্যাসোসিয়েটকে নাতনঘাট পুলিশ স্টেশন। হ্যাঁ নাতনঘাট পুলিশ। হ্যাঁ বলছি কি আমাকে ওই টাকাটা অনলাইনে পেমেন্ট সরকার কি একটু ক্যাশ টাকা তুলে নিয়ে হ্যাঁ তাহলে কি করবে? দেখ আমার কত কোন অ্যাকাউন্টে দিলেই আমার অনলাইন পেমেন্ট এক্সিস ব্যাংকের ইন্ডিয়ান ব্যাংকে করে তো এর ভিতরে অ্যাসোসিয়েটকে দিই একটা অরিজিনাল করবে এরকম তো আমার নেই না আমার কাছে একটা আছে, ঠিক আছে Right. হ্যাঁ ওই দেখি কারেন্ট কারেন্ট ওটা মানে কারেন্ট উপরে আমার কোথায় কারেন্ট ও মানে কারেন্ট হ্যাঁ রাজীবে
অরূপদা কালকে ফোন করেছিল অরূপদা
উপরে টাকা আসলে নিয়ে আসবে খেয়ে দিয়ে এইটা কিন্তু বন্ধ আপনি দেখেন
সেই স্টেজটা তো আমিও বুঝি যে কোন স্টেজে না ওটা অন্য সেটা পরের স্টেজ আমি ওই জন্যই আসিনি পাবেন শেষ করে একটু wait করুন।
বলছি পরপর ডাকবে তো
না 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 এটা না এটা লাগবে
বলছি পরপর ডাকবে তো
হয়ে গেছে স্যার?
আমার ছোটখাটো জিনিস আপনার
আপনার মতো আমার বুয়েট বড় তো
কিছু যেতে বলে সেকেন্ড প্রশ্ন নাই চেক করেছি আসো কিছু নাই এই অর্ডারটা ও এই এটা এটা দিয়ে দিন হ্যাঁ ওটা ঢুকিয়ে দেবো ওটা অমুকাশ ভাই এসে দাম একটু দিকে কি বলে সঞ্জয় একটা কভার ফাইল দাও এই বোর্ড ফাইল দাও not outside. হ্যালো এসেছো আমি কোর্টের ভেতরে আছি তুমি কোথায় আছো আচ্ছা আচ্ছা তুমি ওখানে দাঁড়াও আমি যাচ্ছি According to the complaint, filed by the petition. Right? হ্যাঁ ওই তো কমপ্লেন জমা দিয়েছি দাঁড়া সেখানে আমার বলা আছে তুমি তো বলা আছে তো दो का ही हो गया ठीक है যেগুলো আমি দিয়েছিলাম কবে উঠবে বুধবারে বললাম নভেম্বর কোর্টের ভেতরে কি কোথায় চলে এসো নভেম্বর কেন নয় চলে এসো
সকালবেলায় ধরে নিয়েছি
কি বলছে
এই কলকাতা থেকে টিফিন বক্সে আমার এইটার চামচ চলে গেছে কিনা দেখছিস
হয়তো একটাই চামচ আমার
সতেরোটা দিচ্ছি না কেন দেখো তো তো আমি কর্মস্থ রয়েছে নিচ্ছে কর্মস্থ কিন্তু কর্মস্থ নেই আপনি এখন নেই পরিচালিত হন
তার মানে এমনি বসতে না হঠাৎ করে
এটা কি
বলেছে তোকে জিজ্ঞেস করে
এসে স্ক্রল করে দেখছি
জিজ্ঞাসা করতে হলেন যে এটা কি লিখছো তাহলে গল্প লিখছো
বিষয়টা মনে করছে হলো কি যে মতন ড্রাফট মতন ড্রাফট করতে পারে
বলবি গল্প লিখছো বুঝতে পারি যা হবে হচ্ছে নিজের কাজ করছেন আমি কথা বসে আছেন কথা তারপরে আমি হচ্ছে একটু পরে একটু দেখে দেখে নিয়ে ফোন করি আমি বললাম এই পারমিশন হচ্ছে বললাম যে আমি পোস্টে নিয়ে বলেছিলাম এইসব আমার ক্ষমতা নেই তাহলে আমি বেঞ্চে চলে যাই লাস্টে করি এই টাইম চলে এক সপ্তাহ টাইমে নেই
ওই যখন এক মাস করে
টাইমে নেই বলে দেবো তারপরে তাহলে তো বাড়িতে আমি একটা ক্লার্ক পাঠিয়ে দিতাম একটা ডেট নিয়ে নিত
কি তোলা ঠিক করবি যে বলছিস যে লাস্ট চান্সটা করবো যে ওটা করে দিতে পারতো
অ্যাপ্লিকেন্টের পেজে রেসপন্ডের অ্যাপিয়ার করতো ও তো সেটা যেত অ্যাপ্লিকেন্ট অ্যাপিয়ার করতো ও তো সেটা যেতে পারে তোমাকে তো বেকার বলবে এগুলো তো বলার কিছু ইয়ে নাই জানি এগুলো বোঝা গেছে চলবে তাহলে এটা কি বোঝা এটা তো নতুন কিছু নয় এগুলো আমার শেখা আছে বোঝা আছে আরে অরবিন্দ দুটো ইয়ে দিয়ে দিল ওইটা দেখে দিল দুটো অর্ডার পাঠালো দিয়ে হাঁসটা আরেকটা হাঁসটা আরেকটা ভান্ডারি থেকে পরিচয় বলে 1,000 টাকা কস্ট দিয়ে রিপ্লাই মানে 1,000 টাকা কস্ট দিয়ে তারপর ওরা রিপ্লাই
আগের ডেটেই
হ্যাঁ ও কি করেছে না শুধু জাস্ট কথা অর্ডার আরে ভালো হচ্ছে ওটা দিয়ে দেবো অর্ডার ওকে 100 টাকা যে শরীর খরচা করবে হ্যাঁ দেবেন প্রতিজ্ঞা যদি না দিয়ে থাকে আমি দিয়ে রাখলাম কারণ ভবিষ্যতে হেল্প হবে দরকার হয় এইটাই দেখলাম ভালো লাগে এই হাতের list নিয়ে ঘুরছে, এই বলে বলে দিচ্ছে এই নাম দাম ওদের করাচ্ছে এই হচ্ছে দেখলাম
এক্সটার্নাল ক্লার্ক ফটো দেখার জন্য
হ্যাঁ না
পুরোটাই ওখানে তার জন্য এই মামলাটা ছোট
না না আমি দেখলাম আমি স্যারদের তাদের বাচ্চা কিছু করা যাবে না আমাকে লিস্ট এদিক ওদিক করে ল্যান্ড ট্রাইব্যুনালের ওয়েবসাইট ওরাই নাকি ঠিক করতে দিচ্ছে না চেক হয়েছিল সেটাকে ডাউন করে দেওয়া ভোটার করা দিয়ে কার্ড সার্টিফিকেট কপি ডেট দিয়ে আমি একটা ডেট ঘুরিয়ে নিলাম করতে বাধ্য অন্য ডেট অনেক খিদে পাবে কি খাবে
খিদে পেলে পরে তখন আবার
শশা খাবে বেগুন খাবে আজকে কটার সময় খেয়েছি 8টার সময় রাখলো কোথায়
নাড়াচাড়ার জায়গা ছিল ওর সাথে কথা বলবো
কি বল
চারদিন পারবে না পরের থেকে ও চারদিন পড়াশোনা করবে আপনার বয়স বাচ্চা যত বড় হবে আরো চাপ আরো বাড়বে
আমাদেরকে বলতে হবে যে ও 3 দিনই করবে 4 দিনই করবে
আচ্ছা আসলে পড়াতে যাই একদম বাড়ির সামনে তো হেঁটে চলে
তিন দিন যখন আসবো 2 দিতে যাবে
চেষ্টা করবে 2 মাস পর থেকে চারটে করবার তুমি বাড়াবে ঘন্টা পড়াতেই হবে এমন কোনো কথা তুমি 1 ঘন্টা পড়িয়েও চলে যেতে পারো এটা বলে রাখবো ও আগে বুঝতে পারবে কিনা তার ঠিক নেই। ও বাংলা পারবে বাংলা পড়তে না আমাকে
এড়িয়ে যাওয়া
বাংলা পড়তে পারবো না ঠিক আছে সেটা আমাকে বলেছিল আমি বলে দিচ্ছি শুধু হোমওয়ার্ক কিন্তু কিছু দেবে টাইম আমার
স্কুলের হোমওয়ার্ক গুলো করাবো।
হোমওয়ার্ক দেয় না যেটা দেবে সেটা তুমি করাবে প্লাস পড়াবে আমি তোমাকে বলে দেবো প্রসেসটা তোমার জানলে পরে তোমারও সুবিধা হবে ওরও সুবিধা হবে ঠিক আছে দেরি করে কি লাগে ও তো উৎপাত করছে সবাই ঘরের মধ্যে আমি যাওয়ার আগে অন্তত 1.5-2 ঘন্টা পরে ঠিক আছে 1.5 ঘন্টা তোমাকে টানা ছেড়ে ছেড়ে ওঠে এরপরে সেই যারা আমি বলে রেখেছি এটা ছেড়ে উঠবে না উঠবে খেয়ে দিয়ে একেবারে ও টানা 1.5 ঘন্টা পরে তারপর দুটো সাবজেক্ট পড়াও ভালো করে সাবজেক্টই পড়াও পড়বে না মাথা থেকে দুটো সাবজেক্ট ভালো করে পড়ো আর কোনো HW দিও না সেরকম দিতে পারো যে ওকে তুমি বলে দিলে যে আমি তোমায় পড়ালাম এই কোশ্চেন গুলো দিয়ে যাচ্ছে নেক্সট এসে একটু দেখি সেইটা ও নিজে করবে কিন্তু এর এছাড়া কোনো ইনক্রিমেন্ট এমন দিও না যেটা কিন্তু আমাকে পড়াতে হবে আমার কিন্তু এক্সট্রা পড়াতে হবে খোল ওটা খা আমি খাবো না
কি আছে এটা?
আরে লুচি তরকারি তরকারি বললাম না বলছি সেই ঠান্ডাটা লেগেছে সকালবেলায় যে ময়দা আগে মেখে রেখেছিলাম রেখেছিলাম তরকারিটা বললাম চিকেন ওই একটা দিয়ে এটা হচ্ছে
গলায় কি ব্যথা আছে? তৈরি করে রান্না
তৈরি করে আনা যায় রয়েছে বলে আমি যেগুলো করতে কতটা টাইম আজকে ছিল না বলে আমি এটা করার চান্স এর জন্য তোকে আমি শুনতে পারতাম এই জিনিসটা অ্যাপ্রিসিয়েশন আমার না কাজের মন আছে
আমি তো বলি
রয়েছে অ্যাডজার্নমেন্ট হলো তখন সে কিছু করতে পারলো না ছটা অ্যাডজার্নমেন্ট মানে বুঝতে পারছিস কতগুলো ডেট প্রত্যেকে এক মাস করেও যদি দেয়
এখন তো আবার চলে যাচ্ছে চলে আসবে আগবে না 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 আরে না না আমি আমার বইটা একটা পঞ্চায়েত
আগে আপনাকে
কত লাস্ট হয়েছে
একটা হচ্ছে আপনি হাইকোর্টে আসতে বলে তোমাকে ডিপার্টমেন্ট সমাজ দুটো লিভ সমাজ অনেক
এই যেমন ওই দুজনে আলাদা বেঞ্চ আলাদা খুলে যাচ্ছে কেন লাগছে কিন্তু খুলে যাচ্ছে কি তো যাওয়ার সময় ছোলা মোলা কিনে দিতে হবে। বাসে কি
हाँ हाँ मेरे আগে তো সেটা নিয়ে এইটুকুই আমার টেবিলে দিয়েছে দুটো আমার বলে হ্যাঁ এটা তো নাম লেখা আছে আমার বই এটা অফিসের স্যার এই ফাইল লিখেছেন দাঁড়িয়ে যাও এক নম্বর হয়ে যায় পুরো নিতে হয় এটা করেছেন আচ্ছা হ্যাঁ
পিএম কোনো ফিক্স নেই একটা
তার আগে সাপ্লিমেন্ট পেয়ে যাবে
তারপর তো পিএম ফিক্স হবে
ছেলে হবে আমাদের ঘুমবো আমরা এখানে ঘুমিয়ে নিই তাহলে আমাদের এখন চলে যেতে হবে
তারপরে নেবে যদি আমাদের কেন সাতাশটায় কি আছে
প্রাইভেট ক্লাস
বাইরে তাহলে আপনার এই ক্ষেত্রে আমি যখন ওরা আপনি দিয়ে দাও আপনি দিয়ে দাও পরে দিয়ে দিচ্ছ করে দিতে দাও আচ্ছা করেছি লিস্ট করেছে হ্যাঁ হ্যাঁ একটা তো এই বাসু একটা তো আচ্ছা হ্যালো না হ্যাঁ কি বললো দুটো মেটা বের করেছো বাসু 27 নম্বর 93টা বের করে দেওয়া কোথায় হচ্ছে ওই পাচ্ছ না আপনি একটা আপনার কি আমাদের তো জমা আমাদের ঘটনা হচ্ছে এবং তারপরে আমার কাছে আছে যেমন ধরুন যে আমার বাড়ি ঘটনাটা ঘটে এটা আমি কিছু বলবো না কারণ জ্ঞানী কি বলবো ये काउंटर এটা একটু একটু না
দুই পাউন্ড নাকি 27টা পাউন্ড তোমরা বেতন
না যারা এই যে আপনারা এটা হচ্ছে বেঞ্চ এটাকে করার জন্য আর বলছি কি সার্টিফিকেটটা পেতে সার্টিফিকেট আগে যেগুলো
একটা ফোন করো না পেয়েছো পিলেটা পেয়েছো
সাবজেক্ট টু স্কুটনি তো লিখতে গেলে লিভ ইজ গ্রান্টেড বাস বলা কে বলেছে এখানে ওকে বলছে অপরের নামে দোষ দেয় হ্যাঁ হ্যাঁ ও নাকি বলেছে ভিতরে
কি বলেছে
কে ভিতরে কে বলেছে যারা প্লেন ফাইল করছে সাবজেক্ট টু স্কুটনি
অফিসের সেই
হ্যাঁ লেখার দরকারই ছিল না আপনি লিখতেন এটা ও
আমরা
জানি 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 আমি ছিলাম না দেরি হচ্ছে আমার চলে গেলাম অন্য কোর্টে অনিল বাবু সব কিছু দেবো ইনভেন্টরি ফাইল করছি আর শুধু হ্যাঁ ওটা লিখেছে সাবজেক্ট স্কুটনি ওটা লেখার দরকার কি ইনভেন্টরি আর ইয়ে অ্যাকাউন্টস ফাইল করছে এটা কি প্লেন ফাইল করছে যে পিছনে লিখবে সাবজেক্ট টু স্কুটনি বাই দ্য ডিপার্টমেন্ট হ্যাঁ কে নাকি বলেছে আরে যাই বলো আপনি জানেন না যেই বলুক আপনি জানেন না নাকি বিরক্ত করে আমার মামলা ধরে আমি হ্যাঁ হ্যাঁ তুই চিনিস তো ওগুলো করতে জানি আরো তোকে দিতে হবে খরচা হ্যাঁ বলে দে জানে না উনি এই সঞ্জয় যেটা বলছে সেটা ঠিক একদম
दोनों मिल गया
বাবু
सेकंड
এই
में
বাবু,
मिल गया
মনে কর আমার কোনো ইয়ে নেই
तो मिले बाबा
Respondent number 1.
Well, the interim order was extended, my lord, and was made returnable yesterday. My lord, the learned judge, my lord, was
Honorable judge.
no single learned judge.
Honorable Tom.
Court and single judge. Learned single.
Interim order is going to expire today.
It expired, my lord. It was still yesterday.
MANDA.
My lord, kindly extends the interim order, my lord. It was originally passed, my lord, 2023, my lord. Justice Saraf had passed it.
You are for the plaintiff.
Plaintiff, I'm for the plaintiff.
Yes.
Lordship, I appear for the defendant. My lord, I do not stand in the way because they are enjoying an interim order which is being extended. So,
Well, keeps it after vacation, my lord, any day, my lord.
yes.
Plaintiff and learned advocate for the defendant are present. On the grounds of urgency, the matter is mentioned for listing. This instant matter, the interim order granted earlier expired on 13 May 2024. Stop. On the prayer of the learned advocate for the plaintiff, the state interim order stands extended for a period of 1 week after vacation.
1 week after vacation.
Yes, 1 week after vacation.
1 week after vacation. Well, kindly directs the matter to also appear within 1 week after vacation.
That should not be done because
because it's the different. I understand.
Before the regular.
Yes,
Very well. Deeply obliged, Your Lordship.
Grateful, my lord. Deeply obliged.
Testimony matters fixed at 2 p.m. Item number 27.
Yes, today it is fixed for
No witness action.
witness action. The witness is present today.
Yes, madam. Lord, before my lord, the witness action, may I bring a compilation of paper and the earlier orders? May I give it to your lordship for my lord's convenient?
Was the last order passed?
Yes, my lord. Lordship has passed the last order, my lord.
Presenting the executor.
My lord. Filed by executor.
It is a non-contentious case.
My lord. There is no caveat. We have complied all the formalities. Lord, Lordship desire was to examine the witnesses. You have two witnesses.
Let the signatures and all these things.
Yes, Lord, they are here. May I call him? May I give it to me? Din Joseph. Kindly say last order, my lord. Passed by Justice Sen. The page, my lord, page 60, 7 June 18.
So, department submitted a report that
Yes.
no caveat is lodged.
Nobody there. No, mother has given the will, my lord, in favor of the.
No, because the order says that treated as non-content in the event no caveat is lodged by any of the legal heirs.
Yes. Therefore, my lord, the lordship can pass the order. The general citation has been issued, then special citation has been issued. Now everything is done. All formality is done.
Yes.
Give the copy of will. Will copy thing. Mr. Chandra, look at this document. What is this document for? Will written by whom? What is the date of the will? Now come to the last page of the will. Last page. Who has signed the will? Is it signed in Hindi or English? Was it signed in your presence?
Yes, it was signed in my presence.
Who has signed this? Now, whether it is signed in English or Hindi. You know her signature?
Yes, my lord. I know her signature.
Yes, let the signature be marked exhibit.
My lord.
Will and the signature be marked exhibit.
Exhibit 1. Is there your signature in the last page? You have signed as witness?
Yes, my lord. We have signed that page.
Show the signature. Where is your signature?
Show it to them.
Yes, let the signature.
Yes. Two.
Let it be marked A1.
A1, my lord.
A and the A by 1.
A by 2.
The testator, the witness. A by 2.
A by 2. Lord.
That's all. Yes, so
one more witness. It's
one
like
more witness is there. Yes.
There are 2 witnesses. I am giving both evidence.
Both the witnesses.
My lord.
Yes.
Will. Witness, tell my lord what is this document?
My lord, ये bill है.
Who has written the will?
के द्वारा.
How you know this Sumitरा Devi नाम का?
हरिलाल नगर का.
That. What is the date of the will, tell my lord?
May 2003.
Have you signed as a witness?
We have signed as a witness.
One. Signed.
विश्व देवी जगत के द्वारा साइन किया गया है.
Was it signed in your presence?
हाँ, ये साइन मेरे सामने किया.
Do you have a signature?
Let the signature be, let the will be marked exhibit.
It.
Oh, signature be.
It is signed in Hindi, but will is in English. May I put a question whether it was explained? What is the language of the will? The testator has signed in Hindi or English? Was the content of the will explained to her in Hindi?
ये उसके पति उन्होंने उनको हिंदी में सब समझाया. के बाद में जो है वो गाड़ी हुई. इसके बाद उन्होंने साइन किया.
That is it.
Yes, that's all,
my lord.
Yes, record an order. Learned advocate for the petitioner executor is present. PW1, what is his name?
Lord Atmaram Dubey.
Atmaram Dubey. And PW2?
Devraj Chandra.
Devraj Chandra. are present in court. Both the witnesses are examined in chief and discharged. Documents filed are marked exhibits. As the evidence of the petitioner's witnesses are complete, let 21/5/2025 be fixed for arguments at 3 p.m. Okay, 21st of May at 3 p.m. for arguments.
My lord. I am grateful to you, lords.
এটা থাক রেকর্ডে থাক আর কি ফাইলে থাকবে আর কি
Item number 7.
My lord, there are two applications before my lord. My lord, GA number 3 and GA number 4, my lord. GA number 3 is the application taken out by the defendants for dismissal of the suit on the ground that.
I've heard this matter.
Yes, my lord. I was in reply, my lord.
So where is the other side? You have to give your reply.
We will be replying, my lord. I am led by Mr. Ghosh, my lord. Other side, I
Neither is junior nor he. Nobody is here.
Generally, they are there, my lord.
First of all,
Might have missed it. Maybe start, my lord. They will. If they don't come, then we'll have to stop. Or my lord. We have to finish it today, my lord. My learned junior has already placed most of the facts. I will just go take your lordship through the notes and my lord conclude today. Okay. I'm sure they will come. To bolo na Rajesh da to bolo. Lord, kindly takes our written notes of submission. We were arguing on that only. No.
Yes, your opposition in GA3 is your petition in GA4.
Yes, it's the same thing, my lord. My lord, my learned junior was placing the written notes of argument. My lord, what we have essentially taken in the application for, my lord, extension of time to file, lodge the written writ of summons was, my lord, he was placing the affidavit in opposition, I believe. Right? My lord, kindly, my lord, come to, my lord, the opposition filed by us to, my lord, GA3, that is for dismissal. And my lord, the entire facts, my lord, are here. It's the same application we have made in GA4. My lord, kindly come to, my lord, page 5, internal paragraph, my lord.
Page 5 of your opposition.
Yes, 4, paragraph 4, subparagraph 3.
Paragraph 4.
Subparagraph Roman 3, I believe it is L. No, it is, my lord, subparagraph Roman 3.
Of page 4.
Page 5, my lord.
Page 5. No, page 5 of your affidavit in opposition. That is the written
Affidavit in opposition to GA3. The note ta kothay to diye koto diye porechiস Lord, kindly see page 5, subparagraph Roman 3. As would appear from the plaint filed in the said suit, the same was verified and affirmed by one Anand Kumar Dhanuka, who was one of the directors of the plaintiff company. The said Mr. Dhanuka was authorized by the board of directors of the plaintiff to institute the said suit. In this regard, an extract of the board resolution of the plaintiff dated 5th March 2022, which was signed by one Hitesh Kumar Agarwal on behalf of the board of directors. Copy of the board resolution in 2012 when the suit was filed.
Yes.
The aforesaid Mr. Dhanuka used to look after the litigation of the plaintiff. In such process, Mr. Dhanuka was assisted by one Badri Prasad Agarwal.
Immediately after institution of the suit, the plaintiff also filed an application being J number 1929 of 2012, praying for reliefs in the nature of injunction. Plaintiffs crave leave to refer to a copy. In such application by an order dated 27th August 2012, this court was pleased to record the undertaking assurance given by the learned advocate for the defendants, and the parties were directed to exchange affidavits. Thereafter, affidavits were exchanged by and between the parties herein, respect of the aforesaid application. Subsequently, the said application was dismissed by a subsequent order dated 7 July 2014. Copy of the said order. Now, paragraph 7 is very important. The deponent has come to know from erstwhile advocate on record that during the course of hearing of the said application, a copy of the plaint was in fact handed over to the defendant's advocate on record in court. This is very important. But I make an assertion on affidavit saying that when the earlier round of interlocutory injunction was being moved, a copy of the plaint was in fact informally handed over to the advocate, erstwhile advocate of the defendant. That advocate is not there for them. There is a change of management also in the defendant association.
Well, advocate from your side also, there is a change in
Yes,
from the
yes, both sides. So, my lord, this is an assertion on oath which has been, my lord, denied, but denied by whom? Denied by the present office bearers of the association who were not there in 2012 or 14. Neither their advocates have been there. So, my lord, the benefit of doubt must go to me. And kindly makes a note of this. I have, my lord, threadbare, my lord, included all this in my notes of argument. Your lordship will get it. What I am trying to say from here is this.
Yes.
But what I am trying to say here is this, that had, my lord, the defendants not got the copy of the plaint in 2012 or 2014, my lord, wouldn't it be normal for a litigant in an adversarial proceedings to come up earlier and make an application before the court that, look here, I have not got the writ of summons, I have not got the plaint, kindly dismiss the suit. My lord will be astounded to notice that no such application filed till my second injunction application has been filed in 2024. This GA3 is filed after GA2 has been filed by the plaintiff. So this itself shows that they were all along aware from 2014, 13 or 14 onwards during the interlocutory proceedings that were going on about the plaint. If they were not served with the plaint at the relevant point of time, then they should have immediately come up with an application for dismissal of the suit. But they haven't. When the plaintiff again filed an interlocutory application in 2024, that is when, my lord, this third GA3 has come in. This itself shows that they were, my lord, in receipt of the plaint. Now, my lord, paragraph 7 is a assertion made by me on oath, which, my lord, the present management of the defendant cannot deny or accept, because they were not there in 2014. Neither there, then advocates were there. বস না বাবা, বস 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 বল বস, আধ ঘন্টারও বলবো, বস।
আমি 1 ঘন্টা
সে তো 10 ঘন্টা বল না। So, my lord, page 6, paragraph Roman 7টা দেখাচ্ছিলাম of our affidavit in opposition to GA3. Then, my lord, kindly see Roman 9 at page 6. However, it is subsequently transferred that although the writ of summons was filed on time with the plaint, but the same was not lodged, such omission is not deliberate on part of the plaintiff. Plaintiff does not stand to gain from such omission. Kindly appreciate one thing. I have paid 50,000 court fee. I have made one application. I had obtained orders. Why will I not lodge the writ of summons, which will deliberately not lodge the writ of summons or not serving the copy of the plaint, which will ultimately lead to my loss of 50,000 court fee and the entire legal fees that I've paid for not filing this litigation. It does not stand to logic. Then my lord, plaintiff has already paid the court fee of 50,000 and has also incurred substantial litigation expenses. Plaintiff was initially engaged by Mr. Shayantani Shaw, who instituted the suit. To the best of knowledge of the deponent herein, the plaintiff never received any advice with regard to lodging of the writ of summons. In fact, there was no reason on part of the plaintiff to not lodge such writ of summons. That may be so that even the erstwhile advocate on records were under the impression that since the plaint was handed over to the advocate of the defendant in the course of hearing in the interlocutory application, the formal service of writ of summons may have been waived. So I have not really, my lord, so as to, my lord, transfer the entire guilt on the erstwhile advocate also. I have taken responsibility that maybe she also did not do it because the plaint was accepted in court. Then, had the plaintiff known of such legal requirement, the plaintiff would have taken all steps required for lodging of writ of summons. Owing to lack of such information, plaintiff could not take steps. Mr. Dhanuka was not able to look after the instant litigation for long since he suffered from cancer. In fact, the said Mr. Dhanuka resigned as a director of the plaintiff company on 20th March 2015. My lord, kindly takes this letter once. Annexure C, my lord. That is, my lord, your lordship will get it at, my lord. But there is a letter to the Board of Directors, Annapurna Commercial Company Limited, Annexure C at the top. Yes. Dated 20th March 2015. Your lordship has got it. But kindly see, I hereby tender my resignation from the office of the director of the company with effect from 20th March 2015 and request that a notice of my resignation letter be given to the Registrar of Companies. I request you to please provide me with an acknowledgement receipt of the resignation, the copy of E-Form DIR 12. And my lord, finally, my lord, the other person, just the next annexure, Badri Prasad Agarwal, annexure D, kindly see, he has, my lord, died in 2017. So, my lord, the two people who looked after this case on behalf of the plaintiff, one, my lord, resigned in 2015 and the other died in 2017. Possibly also because of this, my lord, this entire interaction between and follow-up between the erstwhile advocate and, my lord, the company, the plaintiff, was, my lord, interrupted. My lord, I have come clean because, my lord, the present management was aware. I have said in paragraph, my lord, 17 at page 7, I have said that the present management was aware of the suit. Kindly see paragraph page 7. I have come with clean hands. I have said, last paragraph, paragraph 17, Roman 17. Although the aforesaid Sushant Kumar Agarwal was aware of the pendency of the instant suit, the said Mr. Agarwal was unaware of the writ of summons in the instant suit had not been lodged for service thereof. I could have easily said that after my father I was not aware, but no, I said I was aware of the suit, but I was not aware that this technicality of service of writ of summons was not completed. Then, my lord, kindly turns over the page, page 8, Roman 19. Under the aforesaid circumstances, on or about July 2024, the plaintiff filed an application being IGA number 2 of 2024 before this honorable court seeking inter alia protective orders of injunction. Such application was filed by the plaintiff's present advocate on record after obtaining change, kindly, my lord, mark this, from the plaintiff's previous advocate on record on 18 July 2024. So the present advocates have come in and this set of new counsels have come in on 18th of July 2024 when GA number 2 was filed. It is necessary to that since no progress was made in the suit in the last 12 years and since the erstwhile learned advocate on record of the plaintiff has misguided the petitioner about the formal logic of summons over and above the service thereof by hand. Page 9, subparagraph 24, the plaintiff reiterates that the omission to lodge the writ of summons was neither deliberate nor attributable to the plaintiff. The plaintiff is unaware of the process of law. The plaintiff does not stand to gain by not lodging the writ of summons.
24.
Roman 24,
Yes.
page 9. I say it is not deliberate, nor is it attributable attributable to the plaintiff. The plaintiff is unaware of the process of law, and plaintiff does not stand to gain by not lodging the writ of summons. But I do not stand to gain. More importantly, two more points which are not there in the affidavit. Kindly bears with me. One, it is not that, my lord, in 2014, your lordship has seen that the order which I was, my lord, enjoying, that injunction petition was dismissed for default. Dismissed for default. So, my lord, it is not that from 2014 till 2024 or till the taking out of GA3, the plaintiff has enjoyed an order without complying the service of writ of summons, thereby gaining any advantage over the defendant.
So when was interim order passed?
Interim order was originally passed, my lord, in 2012. My lord, kindly come back, my lord, to the my lord, it was originally passed, my lord, in, my lord, 27th of August 2012, where the this your lordship will get page 5, subparagraph 6, Roman 6. 27th August 2012, this honorable court was pleased to record the undertaking assurance given by the learned advocate for the defendant as the parties were directed to exchange affidavits. This was the original order.
2012 and
the dismissal happened in 2014.
Suit filed in 2010.
2012.
2012.
2012 suit filed, 2012 application taken out. Order obtained in August 2019. Sorry, 2012. But, my lord, in 2014, the application got dismissed. So, it is not that by getting an order of court and without serving a copy of the writ of summons, the plaintiff has stand to gain anything. It is not that I was enjoying the order and without serving a copy of the writ of summons and the plaint, I have disallowed the defendant to defend the proceedings and thereby allowed the court to continue the interim order. Nothing of that sort. 2014 only the order got the application got dismissed. So I don't stand to gain. Number 2 and number 3, the assertion made by the plaintiff in that paragraph that the copy of the plaint was served or handed over to the defendant's counsel in 2014 or 12, my lord, is further fortified by the fact that they have not taken out any application for dismissal of the suit on non-service of writ of summons all this while till 2024. My lord, any vigilant litigant, even as a defendant, has the obligation to point out to court that, look here, I am a defendant in this suit. They ought to take out a writ of summons and may not serve the copy of the plaint for me to file a written statement. If they had not received the copy of the writ of summons, they could have immediately come in 2014, 12, 15, 16, 18, 20. No, they come when I take out the second application being GA2 in 2024 for further release, then the brainwave hits them. New advocates, change circumstances. Let us now take a try by saying, oh, we have not been served with a copy of the writ of summons after almost 12 years of the filing of the suit. Whereas I don't stand to gain anything from non-service. That's on factual aspect. This is there. I have shown change of advocates. I have shown the entire management having changed. The persons who were in helm of affairs of the plaintiff not being there. And, my lord, I have said that according to the best knowledge that I have, the plaint was in fact handed over to the defendants' arguing counsels and their advocates representing them at the first stage of the litigation in 2012 or at best as late as in 2014. The new management of the defendant cannot either deny or accept the assertion because they were not there, and possibly there is a change of advocate from them. That is on the factual aspect.
Question is, so far your client is concerned, your former advocate served the copy.
Yes.
Because he is also no more.
He is also not there, but I've said that come to know from us while because my lord, what happened was, my lord, when we were taking change, these questions had come up. When we take change from one advocate to the other, the current advocate had in fact asked the former advocate. We were also having some discussions with the earlier advocate. At that point of time, it was said, though, no, we had served the copy of the plaint at that point of time only. That's why this assertion in this Roman 7 is very important in page 6. Very important. This was done. And my lord, this is very much a practice in this court, that when parties are litigating in an interlocutory application, court sometimes says, please hand over the copy of the plaint, and they will waive service of writ of summons. Now, my lord, I must admit that formal order is not there. Not there. Now, my lord, factually, this is the situation. Now, question is, let us, my lord, say all this that I am saying, is factually not correct. Question is, I have made an application being GA4 asking your lordship to extend the time, my lord, to put in my writ of summons. Question is whether your lordship's court has the discretion and the jurisdiction to do so or not to do so. Now, my learned friend has heavily relied on Todit appliance, a single judge decision, single bench decision, and another decision which has followed Todit appliance. That is his, my lord, argument in sum and substance, that you cannot. Now, my lord, I will kindly take my notes of argument, my lord. Kindly takes my notes of argument. But kindly, my lord, come to paragraph 11.
File any separate?
Yes, I have filed a separate application, GA4.
No. GA4 is for extension of time.
Yes. And GA3 is their application for dismissal.
Is objection filed?
Everything.
Is in both applications.
Both complete.
Both affidavits in both the applications.
Complete.
Okay.
So my lord is really hearing both GA3 and GA4. Yes. It will be a common order which will guide both GA3 and GA4. If your lordship allows GA3, then GA4 is obviously...
Only written notes of arguments is one composite.
Yes, we have filed one composite.
I put both the numbers in the notes of arguments from our side.
GA3 and GA4. This is on behalf of?
I have, my notes says GA3, but my lord, it is a composite argument.
On behalf of the defendants.
Yes, my note says GA3, but my lord, it is really a composite argument for both GA3 and GA4. Written notes contains both the arguments. My lord, kindly takes my notes. Just to, my lord, distinguish the judgments, the single bench decision that my learned friend has cited of Todit appliance, kindly takes in that regard paragraph 11. There is a division bench of this honorable court which has considered Todit appliance and held as follows. Kindly see paragraph 11, page 5. My lord has found that?
Yes.
The plaintiff relies on the division bench judgment of NPR Finance Limited versus Deepak Jhunjhunwala and Rani Leasing and Finance Limited versus Deepak Jhunjhunwala, reported in 2014 SEC Online Calcutta 9623. The relevant extracts of the judgment are as follows. I just quoted for your lordship's convenience. The object of service of summons on the defendant is to make him aware that the suit has been filed against him. If the defendant is otherwise aware, kindly, my lord, mark this. If the defendant is otherwise aware of the institution of the suit, example by reason of participation in interlocutory proceedings or any parallel proceedings, the gravity of non-service or unduly delayed service of writ of summons would obviously be mitigated. Now, my lord, kindly pausing here for a moment. Forget whether he has been served with a plaint.
This was a case where the defendant was otherwise served copy of.
Yes. No, otherwise aware of the interlocutory proceedings. Well, here at least he cannot deny that he was contesting different GA number 1.
Yeah, there was a case that plaint was also served. In your case, it is a dispute whether
no,
the plaint was served or not.
My lord, I am again reading the first portion within inverted comma. The object of service of writ of summons of the defendant is to make him aware that a suit has been filed against him. If the defendant is otherwise aware of the institution of the suit, under which conditions? By reason of participating in interlocutory proceedings or any parallel proceeding, the gravity of non-service of unduly delayed service is mitigated. So even if he is aware that a suit is filed, here he was not only aware, he was contesting the interlocutory application. So he is aware. In some cases, it may happen that due to prolonged terms of settlement between the parties, the plaintiff has refrained from taking steps of service of writ of summons on the defendant. In such cases, also the conduct of the plaintiff would not be so deplorable as to punish him by dismissing the suit. On the basis of the aforesaid ratio, the 4 appeals were disposed of by the Honorable Division Bench by permitting the plaintiff to lodge the writ of summons after a delay of 6 years. 6 years.
Costs.
With costs, I agree. Even after the court found that the application for leave to lodge writ of summons was bald, sketchy, and that no convincing of credible explanation was given in such application. That is not in our case. We have given credible, my lord, facts. We have made assertions. We have said there is a change of advocate. We have said that the parties, the persons in the helm of affairs of the plaintiff are no more, have died or had retired. Then, my lord, kindly turns over paragraph 12. The plaintiff has also relied on the unreported decision in the case of Hindustan Motor Limited versus National Insurance, rendered by a full bench. This is a full, previous was a division bench, now it's a full bench of this honorable court. The honorable full bench approved the judgment of the division bench, that is of NPR Finance. Relevant extracts of the judgments are as follows, which says, and I quote, my lord, thereafter the division bench proceeds to analyze the judgment of the learned single judge under appeal, ultimately relying on the judgments of the Supreme Court in the case of Salem Advocates Bar Association Tamil Nadu versus Union of India, year 2003, Supreme Court 189, and Uday Shankar 3R versus Ram Kelawar Prasad Singh, year 2006, Supreme Court 269. The division bench frames the questions of law and proceeds to answer the same in the following words. Questions now remain if the court can dismiss a suit for laches on the part of the plaintiff in taking steps in the suit. Can the court condone such laches being satisfied with the cause which prevented the plaintiff from taking such steps? Our answer would be yes. My lord, kindly remembers, Todit Appliance says you cannot. Both, my lord, the division bench and the full bench says that you can. In this regard, let us consider the latest Apex Court decision in the case of Salem Bar Association. In the said case, the Apex Court considered the provisions of Order 7, Rule 11, Clause E and R. Such provisions was incorporated, enabling the court to reject a plaint when it fails to comply with provisions of Order 7, Rule 9. The Apex Court observed that such was the enabling provision and the court would ordinarily give an opportunity for rectifying such defect, meaning thereby for procedural laches, the court should not dismiss the suit as a matter of course without giving an opportunity for curing the defect. In a recent decision of the Apex Court in Uday Shankar 3R, the Apex Court considered the provisions of Order 41, Rule 1, which obligates appellant's advocate to sign the memorandum. The Apex Court observed that non-compliance did not entail automatic rejection without giving an opportunity to rectify such defect. Considering the Apex Court decisions referred to above, we are of the view that when the court has power to dismiss the suit for procedural irregularity, the court should have equal power to condone such delay by giving opportunity to the plaintiff for curing such defect. The basic concept in our view is that procedural laches should not take away the substantial right of the litigant, be it his own laches or be it laches on part of his advocate. Either my laches or laches of the advocate, both cannot, my lord, take away my substantial right of allowing the suit to proceed. Then, my lord, paragraph 13. The defendants have relied on the following judgments. The judgment in State Bank of India versus Todit Appliance, reported in 1994, 2CHN 161, rendered by a single bench. And, my lord, the judgment of Bhairu Ratan Pachisia versus International Club, reported in 2007, SEC Online Calcutta, rendered by another single bench. Both, paragraph 14, both the judgments have been rendered by a single bench of this honorable court, whereas the judgments relied upon by the plaintiff were rendered by division bench and a full bench. The judgment passed in Todit Appliance's case proceeds on the basis that the application for extension of time to lodge writ of summons must be filed within 3 years. This has clearly been negated by the division bench and the full bench. Division bench has extended up to 6 years. This is contradiction to the
division bench has considered this.
Yes, Todit Appliance.
Yes.
And has said that no, we are condoning, and they have condoned 6 years of delay, much beyond 3 years. relied upon by the plaintiff where a delay 6 years is condoned. Furthermore, paragraph says appliance was also considered by the full bench judgment of Hindustan Motors. Relevant extract, my lord, where the division bench is considered. Mr. Sen heavily relied on the decision of the learned single judge in case of State Bank of India versus Todit Appliance. The said decision was based upon the Allahabad High Court judgment, which was overruled by the apex court referred to above. The judgment of Bhairu Ratan Pachisia follows the judgment of Todit Appliance and as such is distinguishable on similar facts. Furthermore, none of the judgments cited by the defendant lay down any universal proposition that delay in lodging of writ of summons in a suit is fatal for the suit and the plaintiff ought to be non-suited. So the single bench decision, both single bench decisions have been absolutely, one of them is considered and overruled and the other obviously is based on the other single bench, so obviously constructively overruled by both the division bench and the full bench of this court. My lord, what more do I show? Where, my lord, it is categorically held that your lordship's hands are long enough to consider and have the discretion of extending the time. According to me, I have made out, my lord, grounds for extension. I have not gained any undue advantage for 12 years. It is not that I have an order of court, an interim order, and hence I did not serve the copy of the plaint on him so that I can go on enjoying. Nothing of that sort. Second, my lord, they never came up with an application for dismissal of the plaint on this ground before 2024. They could have also come. This shows that they have the plaint and in any event by the division bench judgment, they were aware of the proceedings. They are aware they're contesting the interlocutory application. So the degree of, my lord, what should I say, degree of, my lord, hurdle that the plaintiff has to cross in this case is much lower. They were aware. They could have sought for a dismissal of the suit much earlier. They haven't done so.
Anyway, relevant decisions you have.
I've recorded and given and I'm giving
in this document, in this argument.
Yes, I've considered and my lord, these are the two decisions. I've already filed before also. Kindly the division bench and the other judgment.
Justice Ajay Nadra's judgment.
Ajay Nadra is their judgment Todit Appliance. I am filing the division bench and the full bench. Which
I've also relied on the division bench, Your Lordship. Just that, sorry.
Yes.
Those are my arguments.
So let him reply.
Yes, he will reply.
Would Your Lordship like me to address Your Lordship today? I can do that so that I'll not take too much time. Very quickly, Your Lordship, first and foremost, I would like
because I have a fixed matter at 3 p.m. Try to conclude it. How long will you take?
10-15 minutes at maximum. First of all,
But then may we come back, my lord. One of my matters got called on. Mr. Ghosh has already left. Since my lord has a fixed matter at 3, may he come back and give a reply on any day?
Anyway, tomorrow?
Tomorrow would be very good, Your Lordship.
Yes.
I'm extremely grateful to my lord.
Learned advocates for the parties are present. Are learned advocates. Hearing of the argument is almost concluded. However, as it is not concluded, the matter stands adjourned till tomorrow, 15/5/2025. I'm keeping it at 4 p.m. At 4 p.m.
That would be adhered. In essence, Your Lordship, I would show that before the Mahabharata began, the Lord of Shri came.
Anyway, you see, reply, there is no scope to
no
add
more
his
fact.
points. Only clarification of the points of law.
Absolutely.
No fresh arguments.
Absolutely, Your Lordship. Absolutely.
Yes, call the 3 p.m. matter.
Item number 93 fixed at 3 p.m. Witness action.
Witness is here.
Yes. The last occasion was the exhibits were till double H. Well,
Double H.
double H. Well, yeah. Showing you this document, please tell my lord what this document is about.
By the managing director. My father. Well, the date was stop.
Yes. This may be marked double I.
Let it mark exhibit II double I.
II. Showing you another document in order to what this one is.
My lord, this is an instrument return report from the Bank of Maharashtra, Chocolate Bazar branch, dated 18th.
Yes, let it be recorded.
Is that 5 lakhs. Reason for this payment of by
This may be marked as exhibit double J. JJ. I'm showing you another document. Please tell my lord what this one is about.
my lord, this is another check by the managing director of private limited, the neglected. My father, the late check dated 18 November 2010. A sum of 25 lakhs was given in favor of my father. An account being checked. This check was stopped. Payment was stopped.
Any other anything else mentioned there in it?
This one,
Yes, stated that it was not honored due to that reason.
Gotcha. This may be marked as exhibit LL. Sorry, KK. Showing you this document, please tell my lord what this one is about.
my lord, this is a check return from the Bank of Maharashtra, Behala Chocolate Bazar, dated 2010. By account number 6004 377 4079. Instrument number 887763. Instrument amount 25 lakhs. Reason for dishonor, payment stopped by Royal.
This may be marked as double L. L. Showing you this document, please tell my lord.
Lord, this is another check issued by Calcutta Resource Private Limited. Vice Director of my father, the plaintiff. Check dated 30th November 2010. A sum of 25 lakhs was drawn in favor of my father. This check was, however, dishonored due to payment stop.
This may be marked as exhibit double MM. Showing you this document, please tell my lord what this document is about.
My lord, this is another instrument from the Bank of Maharashtra. Dated 1st December 2010. Bond by account number 6004377 name Honorable Resource Private Limited. Instrument number 887764. Instrument amount 25 lakhs. Reason for dishonor, payment stopped by drawer.
This may be marked as exhibit double N. So I'm showing you this bunch of documents. Please tell my lord what this is about.
My lord, this is the income tax return of the plaintiff for the assessment year 2009-2010. Wherein it states that income from of Japan guest house is 48 lakhs 60,489 for the year ended 31st March 2009. Japan guest house. ये गवर्नमेंट
I have to put that question. Identify the signature of Gopal Govinda Ghosh and identify, so encircle them in blue ink. You may encircle all the signatures that you are identifying.
Signature of Govinda Ghosh is being marked exhibit.
Yes, yes. So this may be marked as double O, and the signature may be marked as double O by 1. Collective.
Yes, collective.
Tell my lord what this document is about and show.
My lord, for payment of taxes, property taxes, in respect of premises number 38 Vista Gully Street. By my time, Henry dated 29 January. Here, at the top of 11,852 was here.
This will be marked as PP. I show you another document. Tell my lord what this one.
Here, this is by the Calcutta Corporation in respect of premises 38 Vista Gully Street. And January 2005. All tax was paid in respect of property tax on by my father the plaintiff.
This may be marked as QQ. QQ double Q. Lordship, if you may pause here for the day, this part.
Okay. How many documents are yet to be exhibited?
We are trying to curtail it.
Okay,
but
not learned advocate for the plaintiff is present. PW1, what is his name?
Udhaditya Ghosh.
Udhaditya Ghosh is present in court. PW1 is further examining chief and discharged for the day. documents filed be marked exhibits. On the prayer of learned advocate for the plaintiff, further examination is adjourned till anyway after vacation.
After vacation.
19/6/2025,
Yes.
19th of June
19th of June.
at 3 p.m.
Item number 10,
Appearing on behalf of the plaintiff, my lord.
This matter was heard.
The application. We have filed application GA16 and it's going on here.
I was addressing your lordship, my lord.
My lord, before Mr. Mukherjee starts, my lord, one issue, my lord, which my lord, I should bring
All
to.
parties are not here before.
No, but that's all right. Not an issue, my lord. If my lord wants to take up, I will take up. Kindly see, my lord, my lord's list. My lord, from item number 10, my lord, 11 onwards.
Yes.
My lord, the host of applications which were there day before, on 7th, on 1st, papers were there. Suddenly, I find that there has been with the endorsement no paper. The papers were there. My lord took up, my lord, the applications in my lord hand.
No, I have fixed this matters when.
That's
Today?
what. No. My lord, kindly see, my lord, the list. My lord's daily list.
Oh, right. File is not here.
No, files were here.
Huh?
Files were here.
No, some applications have not come from the department.
No, those were there. Those were there last day.
Specifically,
There was no such.
I am now hearing that GS16.
That's all right. Millard, I am not on that.
GS16.
But Millard, suddenly overnight, Millard, a file which was here, Millard, that can't be, Millard, vanished with a magical wound.
Anyway, they will look into this matter, whether it.
Well, that is all right. I am not on that. Millard, I am on the files
come from the
on
department.
1st, Millard, in April, on 1st of May, on 7th of May, files were here. My lord, even Millard took up in my lord's hand, Millard, thereafter, my lord had decided to take up IAGA 16, that's all right.
Yes, that is being taken up.
Yes. But Millard, kindly see my lord's order, Millard, files were here.
Anyway,
now, Millard, files cannot get vanished like that.
Anyway, it has to be brought into it.
No, that's at an alarming position, Millard. Files cannot get vanished like that. Millard, what do I say to the clients? These are all our on website. They see that they have called us. That last several days our applications are on list. Suddenly one night no paper. And Millard, collectively Millard, our application. Kindly don't take me amiss. Millard, specifically our application.
How many?
G18, 19, 20, 21, 22.
18, 19,
20, 21, 22. Those are the expunging. Millard, recollect, these are my submissions.
Okay.
That Millard, that's the point of maintainability.
Okay, 18, 19,
20, 21, 22. I'm concerned with those.
20, 21 and 22.
Those are all there. My lord, past orders.
এই আগের ইয়েগুলো কি ছিল না নাকি আগের দিন পেপারস গুলো? এই অ্যাপ্লিকেশনস গুলো তো কারেন্ট অ্যাপ্লিকেশনস, বেশি পুরনো তো নয় অ্যাপ্লিকেশনস গুলো।
লাগে না কি? দেখ উপর থেকে ওয়াইফাইটা আমি কানেক্ট করি।
তাহলে আপনারা দেখুন নইলে সোমবারে তাহলে জানাতে হবে রেজিস্ট্রারকে। হ্যাঁ, ঠিক আছে, এটা অর্ডার রেকর্ড করুন। In terms of earlier order, GA 16 of 2022, GA 17 of 2022, GA 18 of 2023, GA 19 of 2023, GA 20 of 2023, GA 21 of 2023, GA 22 of 2023, GA 23 of 2023, GA 24 of 2023, and GA 25 of 2023 are appearing in the list. However, there is no file with regard to GA 17 of 2022, GA 18 of 2023, GA 19 of 2023, GA 20 of 2023, GA 21 of 2023, GA 22 of 2023, GA 23 of 2023, and GA 24 of 2023, and GA 25 of 2023. Stop. In spite of requisitions, the files have not come before this court. In the facts and circumstances, these matters cannot be taken up today. The hearing of this matter stands adjourned till 21/5/2025. The register original site is requested to cause an inquiry and submit a report by 21/5/2025. Stop.
Before that, the matter will be over.
Yes, I'm keeping it again on 21/5.
Yes, let the papers come.
Yes.
আচ্ছা GA 21টা ইয়ে করে দেবেন, GA যেটা আছে 16 of 2022
হ্যাঁ,
মানে
বলে দিয়েছি
10 নম্বর আইটেম, ঠিক আছে?
25 of the
Learned advocates for the parties are present. Let this matter appear on 21/5/2025 along with the other matters. Yes, come on 21st.
Yes. But all my application should also appear. My lord. We have
all
বলে দিয়েছি
G16 and
I mean, that has to be
It will be hard out.
hard out.
On
Yes. That doesn't mean no paper stage it will be done.
no.
It will be hard out on 21st.
Yes.
Paper.
papers are not.
Actually, other applications could not be taken up anyway. Although I'm hearing GA16, I've directed to appear on 21st. You have made your submissions.
I have.
So let the
I was responding, my lord.
21.
ঠিক আছে
তাহলে এটা রাখো।
চলো 21
এই, এটা রাখো।
oblige 21 তারিখ my lord
Yes, next.
Item number 22.
नहीं নাকি লেখা আছে not file missing বলে।
আমারটা 12 to 17 একটু নামটা দিয়ে দেবো।
Item 22, okay, not today.
12 to 17 কেউ নেই লেখার মতো।
Item number 23.
Item 20.
Item
22.
Yes.
22 or 23?
22.
22, yes. You are for?
I am for the plaintiff of the suit, my lord. The third party has filed an application for an intervention. Lordship gave direction for filing opposition. My lord, the time has expired, my lord. I have affirmed the affidavit. Kindly accept it.
Affidavit in opposition.
Yes.
Yes. Record and order item 22. Learned advocates for the parties are present. Affidavit in opposition to GA 6 of 2024 is filed by the learned advocate for the plaintiff. Let it be kept with the record. Anyway, you want time to file reply? Liberty to file affidavit in reply is granted till
1 week after the vacation.
Till 1 week after the vacation. Let this matter appear on 18/6/2025.
Item number 23.
Dependent number 3, last petition on 21st of April 2025. Your lordship was pleased to direct the defendant to file the opposition, your lordship. This is the opposition. May I hand over?
GA 3.
GA3. This is a
Okay.
restoration application and 2,203 days delay.
Okay, this is GA3 of 2024 plaintiff's application for restoration.
Yes.
You are filing the affidavit in opposition.
On behalf of defendant number 3.
Okay, record and order. Learned advocate for the defendant number 3 is present. Learned advocate for the defendant number 3 files affidavit in opposition to the application GA3 of 2024. Let the same be kept with the record. Affidavit in reply may be filed by 10/6/2025.
Your Lordship, only one thing, Your Lordship, since it has been affirmed yesterday, so I was unable to serve.
Serve it in the meantime.
In the meantime, I will serve the opposition.
Okay,
By tomorrow, I will serve.
I am keeping this matter. I am directed affidavit in reply be filed by 10/6.
As Your Lordship.
Let this matter appear on 12/6/2025. Service of affidavit in opposition must be made in the meantime.
As great.
I don't know. Testamentary matters, item number 24.
Yes, not today.
Item number 25.
Not today.
Item number 26.
Not today.
Item number 27.
27 হয়ে গেছে তো।
27 হয়ে গেছে। Oh, 27. Item number 28. Old suits.
Yes, 28. দেখি লাস্ট অর্ডারটা কি পাস হয়েছিল।
বলো।
Oh, none appears for the party. Matter record করতে হবে। Yes, record and order. None appears for the parties. It appears that on 23rd April 2025, none appeared and the matter was adjourned till 7th May 2025. Stop. Today also, neither of the parties have appeared. However, in the facts and circumstances, the matter stands adjourned till 12/6/2025 as a last chance.
Item number 29.
দেখি কি অর্ডারটা দিয়েছি আগে। হ্যাঁ, এর জন্য এটাই এই অবধি ছিল। ওকে, সেম অর্ডার।
Item number 30.
একই আছে অর্ডারটা, সেম অর্ডার।
Item number 31.
সেম অর্ডার।
Item number 32.
Your
Same
Lordship,
order.
This matter, Your Lordship.
32.
Yes, Your Lordship. On
32. Yes, you are for?
I am appearing on behalf of the defendant bank, Your Lordship.
Yes, yes,
On
yes.
the previous occasion, Your Lordship, you have pleased to instruct us to make the other side, the defendant, to plaintiff to serve a copy of the order, Your Lordship. We have served.
Yes.
Kindly. I have served the plaintiff as well as the advocate on record of the plaintiff. Your
Yes,
Lordship.
yes, yes. Let me see.
The advocate on record of the plaintiff, I have received the letter, Your Lordship. Kindly have a look of the affidavit of service, Your Lordship, in page number 4.
Okay. Item 32.
Although the plaintiff
32 এটাতে
company has not received it,
Although the plaintiff company has not received it, Your Lordship, but the advocate and record of the plaintiff have received it. I think they are not in the capacity to perform their duties. Can I dismiss the suit, Your Lordship?
So let an administrative notice be issued. Yes, record. Uh, so plaintiff could not be served.
Plaintiff could not be served, Your Lordship, because their address, the address as per the cost title, we have served them, but insufficient address.
Oh, it could not be served.
It has been returned as kindly.
Okay. Learned advocate for the defendant is present. None appears for the plaintiff. Learned advocate for the defendant submits that in terms of earlier order dated 23rd April 2025, notice was served upon learned advocate for the plaintiff, intimating the date fixed. Stop. As none has appeared on behalf of the plaintiff, let an administrative notice be issued to the plaintiff and its learned advocate, and report be submitted by 19/6/2025.
For appropriate order, Your Lordship.
For report.
For report. Let the envelope be kept in the record, Your Lordship.
Let the envelope which is returned from the plaintiff's, which is returned, be kept with the record.
Your Lordship, can it be the advocate on record has received the intimation, Your Lordship?
I have recorded that. That you have served the learned advocate for the plaintiff.
Item number 33.
33. Okay, same as 31.
Item number 34.
Yes, same as 31.
Item number 35.
Yes, same as 31.
Item number 36.
Same as 31.
Item number 37.
Same.
Item number 38.
Yes, Madam, I am appealing for the defendant.
38, yes.
Yes, Madam.
Let me see the order, earlier order.
Earlier, none appears, it was written, Madam.
Earlier occasion you appeared.
I failed to appear when I missed the.
Anyway, let item 38 yet in order last.
For defendant. Item 38 लिख दीजिए.
Record an order, item 38. None appears for the plaintiff. Learned advocate for the defendant is present. However, none appears for the plaintiff. However, in the interest of justice, the matter stands adjourned till 17/6/2025.
I informed the
Yes. Learned advocate for the defendant is requested to intimate by notice learned advocate for the plaintiff and the plaintiff. So 17/6 it will appear.
I oblige, Madam.
Item number 39.
39, let me see the last order.
Yes, 413.
No, 39.
Coming. Didn't you open the dorsal? But it's not dorsal looking for dynamic. Then we're all helpless. It can't. It will all everything. Yeah, it's I have to put the button. That can't down with the button. And this one.
কত হলো না এটা 39 তো অন্য সিএস 413
আসেন
আচ্ছা 39 not today.
Not today. Item number 40.
My lord, I am appearing for the liquidator.
Yes.
I have not received the Vakalatnama from my client. So, lordship, kindly put this matter after vacation.
Yes, item 40, please record an order. Learned advocate for the plaintiff liquidator is present. Learned advocate prays for time to file the Vakalatnama. The matter stands adjourned till.
My lord, court liquidator.
Yes, after vacation. 11/6/2025. Stop. Learned advocate is also requested to intimate the learned advocate for the defendant about the next date fixed.
Item number 41.
Lord, I am appearing on behalf of the plaintiff. Your Lordship, on the previous occasion, I have prayed for time to file my Vakalatnama, Your Lordship. So I have filed my Vakalatnama on today's date.
Yes. At what stage the suit is?
Since this is a changed brief, Your Lordship, I need some time to go through the brief. Kindly keeps this matter after vacation. Your
Okay. Item 41, record an order. Learned advocate for the plaintiff appears and prays for time. The matter stands adjourned till.
My lord, the Vakalatnama is filed.
That is okay. The matter stands adjourned till 16/6/2025. Learned advocate is requested to intimate the learned advocate for the defendant and the defendant.
Grateful, Your Lordship.
Intimate the defendant and the defendant's advocate by notice.
Grateful.
About the next date.
Item number 42.
Not appearing for the plaintiff. I was appointed the receiver. The plaintiff was appointed the receiver in place and stead of the erstwhile receiver. But the application for discharge of receiver is GA12. That was effectively allowed, but since I had disputed the accounts filed by the receiver, it was not yet disposed of. Now in 13, my learned friend is appearing for the receiver.
Erstwhile receiver.
Yes. In GA13, my lord, I had prayed for certain directions.
GA13, you are appearing for the receiver.
Receiver come plaintiff. Party receiver.
Plaintiff.
Plaintiff
Party
receiver.
receiver.
Now
I for the erstwhile receiver.
In his place.
Receiver.
Yes.
There was in my learned senior's application, there was a direction upon me to file an affidavit. I could not get the affidavit affirmed by the commissioner in as much as the erstwhile receiver, pardon me for saying this, is not in a state where he can either move and come and affirm before the oath commissioner. I had caused letters to be issued to the oath commissioner for the purposes of having it done on commission.
Yes.
On one occasion, first letter was issued sometime in November, 23rd November 2024. However, that could not be materialized. I am led by abundant caution
caused making of an affidavit by the clerk of the erstwhile receiver have also served on prior notice before the filing of the same to my learned senior friend appearing on the other side and the other parties in the suit. I have once again, my lord, on the last occasion it fell from my lord that my lord is intending to appoint an audit with respect to the accounts. My only prayer, I cannot at all stand in the way of an audit because I have nothing to hide. My only prayer before my lord is, I have once again applied for the affidavit to be affirmed by the oath commissioner on commission.
An order.
If my lord keeps in a
Learned-
specific date, I can file
learned
my
advocate
affidavit.
for the plaintiff and learned advocate appearing for the receiver are present.
Erstwhile receiver.
The erstwhile receiver are present. It is submitted by the learned advocate appearing for erstwhile receiver that due to serious ailments of the learned receiver, the affidavits could not be affirmed. Learned advocate prays for time. The matter stands adjourned till 17/6/2025.
No, this is only with respect to GA 13. With respect to GA 13, I have
25 for further hearing of GA 13 of 2024.
yes. With respect to the other GAs, there are no allegations against me. I have no role to play.
Applications be heard out on the next day.
Well, so far as 14 and 15
I
is
have
concerned,
nothing.
my lord, your lordship can take them up because the erstwhile receiver has no role
14,
to play.
15 for
14, my lord. হ্যাঁ কিসের GA 14 এর হ্যাঁ এই তো হ্যাঁ এটাই কপি এই 14টা দেখি 14টা
14 কি নেই পেপার নেই Okay, let the papers come.
Very
GA
well.
14.
14 and 15, my lord.
Yes.
15 only?
Monday. Okay, I have fixed that GA 13 on that is on
Sometime in June.
sometime in June. So let it appear in the
But
meantime.
these applications can be, there's some urgency, my lord.
No. What have you prayed for in these applications?
My lord, one is with regard to a direction on the receiver to treat the certified copies of the property in question as original because the original deeds were kept in custody of some other persons who have, my lord, have been served with this application. They had appeared, they had sought for filing affidavit. Till date, no affidavit has come.
Anyway, come on.
That was the prayer.
Good.
And the other one, my lord, 15, I have prayed, my lord, certain directions on the Kolkata Municipal Corporation to effect change in their records.
Okay, I shall take it up on the same date. In the meantime, you serve notice.
Your Lordship,
Notice has been
I
served. They
am
are all
I am appearing on behalf of the defendants, Your Lordship. The issue is this is pending for a long time.
Yes.
And now, unless these records are straightened out, Your Lordship, no steps can be taken because we are at par with the party receiver, the plaintiff. We are also the co-owners of this property. Now, in the application, which my learned senior friend has pointed out that a third party is holding on to the title deeds, they did not come forward to file anything. Now, since the original deeds, we are only trying to rely upon the certified copy as the original and proceed with that. Hence, if your lordship kindly takes up these applications any day, these will only take only 1 or 2 minutes of your lordship's time.
Let the file, এই order record করে নিন. Let the file of GA 14 of 2000
and 15, my lord.
And also 15, your lordship.
And GA 15 of 2025 we put up on 20th of May 2025.
And also 15, if your lordship pleases, because in 15
14 and
we
15?
yes, your lordship.
20th of May.
Very good.
Grateful,
Deeply
your
obliged.
lordship.
Let GA 14 and 15 appear on 20th of May.
Grateful.
Great. Item number 43.
43. Yes, not today.
Item number 44.
Not today.
Item number 45.
Not today.
Item number 46.
Yes, same, not today.
Item number 47.
Same,
Item number 48.
same.
Item number 49,
Same,
item number 50,
same,
item number 51,
same order,
item number 52,
same,
item number 53,
same,
item number 54,
same,
item number 55,
same,
item number 56,
same,
item number 57,
same order,
item number 58,
same,
item number 59,
same,
item number 60,
same,
item number 61,
same order,
item number 62,
same order,
item number 63,
same, not today,
item number 64,
not today,
item number 65,
not today,
item number 66,
not today,
item number 67,
not today,
item number 68,
same,
item number 69, item number 70, item number 71, item number 72, item number 73, item number 74, item number 75, item number 76, item number 77, item number 78, item number 79, item number 80, item number 81, item number 82, item number 83, item number 84, item number 85, item number 86, item number 87, item number 88.
Not in item number 88.
yes.
Lordship, I appear for the plaintiff in item number 88. I'm led by Rajoshi Dotto in this matter. Lordship, I'm praying for a passover, short passover.
Let it be not today, it cannot be taken up.
Possibly one clarification. I am the receiver appointed. I personally will not. There was a direction upon me to conduct a surprise visit to the subject property for the purposes of ascertaining the electricity connection and a few other things with ingress egress with respect to the property. If my lord kindly takes the order, there was a direction that such will be conducted only after the joint funds are released. Now, my lord, there is no joint funds per se with respect to this property. The issue is one of the parties have paid their share of the remuneration with respect to the conduction of my duty. The remainder, my lord, is left in a limbo.
This is a
Yes.
Take it up.
Yes.
Let it
Lordship,
be not
in the-
today.
Yeah,
The case
kindly,
of the other side, I shall take it up tomorrow.
Because, my lord, I am stuck between both sides. I don't know whether I am to or not to take steps as per the direction.
Okay, come tomorrow.
Extremely obliged.
Sir,
Not today.
I've kept it tomorrow.
Yes. For hearing item number 89.
Yes, not today.
Item number 90.
Lordship, I'm for the respondent. I'm the decree holder and opposing a third party's application kindly keeps it after the vacation.
Okay, 90.
I am for the degree holder. My lord, I am praying for not today.
You're for the?
I'm the respondent. I'm the decree holder.
Not today.
Not to-
Not
Yes, item number
90.
90.
90.
Just make it not today or after vacation?
Not
After
today.
vacation.
Lordship, keep it after vacation.
After vacation.
What is the matter?
Ma'am,
But I am for the
what is
judgment that a decree holder has filed.
Okay, item 90, please record an order. Learned advocate for the judgment debtor and learned advocate for the decree holder are present. On the prayer of learned advocates, the matter stands adjourned till 12/6/2025. Okay, 12th of June.
Okay. Grateful.
টার্নার মরিসনের মামলাটা কত? টার্নার মরিসনের মামলাটা নাই।
Item number 91.
But item number 91, I'm for the defendant, my lord.
And I am for the plaintiff, my lord. Here, my lord,
It is fit for framing of issues.
no, my lord.
But the inspection has to be completed first, my lord.
Plaintiff has, I have, the defendant has filed a written statement and made a counterclaim, my lord. The
Yes.
inspection is required, my lord. Only the
Sovereign inspection is not completed
not
by both the
completed
parties.
because, my lord, the court from Holdia, my lord, it's not traceable. My client is trying to find out some original document. That's why I could not give some inspection of those documents. Lordship kindly give some more time, my lord.
I do not stand in the way, my lord.
Those original documents
Mr.
are,
Mitro,
yes,
you
my lord,
are-
I'm led by Mr. Mitra, my lord.
Okay.
Will lordship keep it in monthly list of July,
Okay,
my lord.
learned
It will take some time.
advocate For the plaintiff and learned advocate for the defendant are present. It is submitted by the learned advocates that discovery and inspection is not yet complete. Thus, this matter stands adjourned till, I'm keeping it at the end of June.
Well, give July monthly list of July.
July, my lord. It will take some time, my lord. I have to also give for inspection also.
Adjourned till 2nd of July 2025 for completion of discovery and inspection within the said period.
Deeply obliged.
But I just missed that matter. Your lordship was calling item number 90, Turner Morrison.
89.
89, Turner Morrison.
You are for?
I am for, my lord, the respondent in that matter. My lord, I had to give the affidavit in opposition. I'm only seeking for an extension. That's all. Your lordship can keep it on 12th of June, I believe.
Your application,
No, my learned friend's application, I am supposed to give the affidavit. I am
respondent or defendant?
respondent, my lord. Plaintiff,
Yes,
respondent.
record and order.
plaintiff.
Mr. Ghosh, learned advocate for the plaintiff respondent is in GA 9 of 2024 is present. Learned advocate prays for time to file affidavit in opposition to GA 9 of 2024. The prayer is allowed. Let affidavit in opposition be filed by 10/6/2000.
10/6,
2025. Reply, if any, by 16/6/2025. Let this matter appear on 18/6/2025.
My lord, affidavit direction was also already given. It is an extension.
Yes, yes, yes.
Extension. Your lordship said.
Yes, if the moment I extend your time, the other time has to be extended.
Yes, no. Your lordship said they are wanting to file an affidavit in opposition. Kindly, if you can record that, wants an extension of time to file.
Mr. Ghosh, learned advocate for the defendant is present.
Plaintiff respondent is present.
Item 89.
89.
Prays for time.
To and seeks for extension of time to file affidavit in opposition.
Learned advocate for the plaintiff respondent seeks extension of time
My lord.
to file affidavit in opposition.
Rest, my lord, is absolutely all right.
ঠিক আছে, বাস ওইটুকু।
10th of June and then, my lord, 18th.
Yes, 10th, then
18th.
10th, 16th, reply.
16th and 18th.
And 18th, the matter will appear.
He's for the petitioner.
Yes.
Yes, I have extended the time to file affidavit in opposition. Reply, if any, by 16th of June, matter to appear on 18th of June.
আমার appearance হ্যাঁ please
Item number 90.
90 to where? 93.
Huh?
93.
Training of issue stuff.
Where actually? 297 of the.
Oh, item number 93.
Not today.
Item 94.
94, I beg to appear for the defendant. Lordship, kindly consider Lordship last order, my lord.
Speaks for witness.
No, my lord, not for witness. Now the, my lord, the proceeding is pending before Lordship, my lord, for ascertaining the mean profit. The court has appointed a special referee, my lord. Last occasion, Lordship is pleased to extend the time for filing of the mean profit. Now, my lord, the proceeding is already concluded before the special referee, my lord. The argument has been exchanged today. So now, my lord, the referee's report is due.
Time has to be extended.
My lord, the referee is not present, my lord. I can only, my lord, submit before Lordship, my lord, that we have already submitted our written notes of argument, my lord.
Let it appear after vacation.
After vacation, my lord. I think, my lord, in the meantime, he will submit.
94, item 94. Learned advocate for the defendant is present.
The defendant bank.
Defendant bank is present. On the prayer of the learned advocate, the matter stands adjourned till vacation. Let it appear on 10/6/2025.
Lordship, before my lordship rises, may I seek
10/6/2025. Yes.
may I seek your lordship's kind
For
indulgence?
submission of the special referee report, my lord.
You have just simply adjourned it. Whatever instruction you want to take, you take on that day. Yes.
Lordship, item number 38.
when I entered the courtroom, there was a confusion between 38 and 39. I'm
Item
appearing for the
30.
38, Your Lordship, 38.
38, yes.
I'm appearing for the plaintiff number 1 in this matter, Your Lordship. Plaintiff number 1. But at that time, the board was showing 38, 39, and there was a slight
Have
confusion,
adjourned it.
Your Lordship. Yes, if Your Lordship, I could kindly. Your Lordship has been pleased to adjourn it to 17/6. I understand we'll come and trouble Your Lordship on that day.
Come on that day. Serve notice upon the other side.
I will serve a notice upon the other side, Your
I have
Lordship. May I
adjourned it. I
kindly
have made
give
it.
my appearance? I'll serve a notice
I've
upon the
already
other side.
recorded, none appeared. It's better you do one thing.
Yes, Your Lordship.
আচ্ছা item 38 আচ্ছা ঠিক আছে একটা
Sudhir Ashish.
অর্ডারটা আচ্ছা learned advocate for the plaintiff ওটাকে কেটে দিন তাহলে অর্ডারটা
Your Lordship, I'm only appearing for the plaintiff number 1. There are two plaintiffs.
item 38 learned advocate for the plaintiff is present.
Plaintiff number 1, Your Lordship.
Item 38 learned advocate for the plaintiff number 1 is present. On the prayer of learned advocate, the matter stands adjourned till 17/6/2025. Learned advocate is requested to serve notice upon the defendant and the learned advocates. Serve notice.
I shall do that, Your Lordship. I'm humbly. Thank you.
দেবে না কখন আর কোর্টের সাথে তোমার